It may be listed tomorrow.
I beg to mention item number, my lord, 30 and 31, my lord, with the consent of the other side, my lord. I have some personal problem today. So maybe taken up in the next week, if it's possible, my lord.
On 11th, your lordship.
Mr.
J. Sharma.
J. Sharma. Learned counsel for the petitioners raised for adjournment, stating that he has some personal problem. Full stop. He also submits that he has taken the consent of the other side. Accordingly. And Mr. Who appears for this?
I am for the private respondent.
Mr. S. Bhattakur appears for the private respondent, and Mr. D. Gogoi. R. Gogoi appears for the forest department. List the matter
On 11th.
on 11th.
Obliged.
Next is your lordship. Madam, I beg to mention this item tomorrow for withdrawal, madam. I'm obliged.
I would like to mention for a listing of an item, my lord, it was last listed on 23/1. Lord, it was non-payment of contractual dues, my lord. It may come up any date, my lord, on next week. Public.
Yeah, please, your lordship. My lord, I prepare listing for withdrawal, madam. Tomorrow.
Your lordship, listing a contempt case for tomorrow.
Why? Contempt case, what is the agency?
Withdraw my senior,
Huh?
my senior tell me withdraw this case. Contempt case number 161.
Yeah, for withdrawal.
For today and listing it for tomorrow.
For withdrawal, okay.
May please, your lordship, my lord, in item number 21, my lord, ma'am.
Yes.
Here, my lord, an affidavit may be brought on record, my lord.
Huh?
My request for bringing on record an affidavit, I'll give your lordship. Obliged.
Please, your lordship. The matters related, it's a writ petition.
Huh?
It's a writ petition. The matters related to writ petition.
Yeah.
And it is regarding selection and appointment of governors. So may I kindly request you to give any date next week?
Okay.
My please, lordship. I want to withdraw that subject.
Mr.
R. Ali.
R. Ali, learned counsel for the petitioner. Petitioners praise that he may be able to withdraw the writ petition. Mr. S. Bora appears for the GMC. The prayer of the petitioner's counsel is allowed. Writ petition is dismissed as withdrawn.
That, my lord, the petitioner is a reputed, my lord, contractor of the LLP farm, my lord, by taking over one CNA brothers. My lord, if labor from JB, my lord, is a MSC farm, it can participate in tender individually, my lord. What happened, my lord, in 2022 last, my lord, the petitioner participated in a tender issued by the railway, my lord. In a railway, my lord, petitioner participated in a tender. Right. Issued by the rights. So.
No, what has happened to that letter?
That letter, my lord,
17/3/23.
My lord, the railway board has.
Huh?
My lord, the railway board has inquired with the chief administrative officer. My lord, page second, my lord, third page. In view of the above. In view of the above, my lord, the railway is requested to offer their remarks on the following aspects. It may be clarified under which circumstances Zonal Railway has come to conclusion for revoking the banning of business against Messrs. Samcon Infrastructures LLP. Whether any investigation has been carried out by the Zonal Railway before reaching at final decision of revoking banning business against Messrs. Samcon Infraventures LLP. It may be mentioned that the grounds for revoking the banning against Messrs. Samcon Infraventures LLP after a lapse of 6 months. My lord, what was banned was a joint venture. And my lord, earlier, my lord, the another joint venture, my lord, it approached the honorable court by filing a writ petition. That was dismissed.
No, so what has happened to this letter?
My lord, the railway has, my lord. the
So
railway
has
This is
the zonal railway
Not
given-
replied, not replied yet. This is the query raised by the railway board. That if the joint venture was banned where two entities, both the entities were banned. And one of the entity, my lord, approached by filing this writ petition, my lord, 7057, which I have given.
Yes.
That writ petition was dismissed. And same impugn order is challenged in the present writ petition. Now, my lord, one venture is saying that, my lord, I was not part of that joint venture.
He's saying,
He is saying, my lord.
he's not part of the joint
He
venture.
was fraudulently, my lord.
And in this case, what was the issue?
He issued another 5 years banning is there. They prayed for the court that it should be reduced. Then court allowed them to file a request before that court. And in that judgment, if your lordship see page 5, page 14, they have admitted that forgery has been done by him. Para 14. The land extending council submitted a contract of petitioner is also very relevant in this case. He got to be taken to consideration before taking this one the issue at hand. He submitted allegation is forging of documents of another company so as to enable itself to submit its bid. But it's interesting to note that the use of the forged documents as such has not been denied by the petitioner. And only explanation is that they were not aware of such forgery. So, I never formed any JV, my lord. I never put any signature. And I was shown as lead partner, my lord. And no stoppage has been issued to us, my lord, before banning the farm, my lord. Similar, my lord, matter has been earlier, my lord, came before lordship, my lord, just your lord. 1 minute. Similar matter, my lord, when forgery has been done, one matter, my lord, came before lord, this honorable court, my lord, your lord, my lord, earlier the person of that, my lord. Because why I should be penalized, my lord? I never formed any JV. But here we lodge.
Now, what is to be done?
Call has to be taken by the railway board now.
So you take, when are you taking the decision? You take it.
My lord.
When is the zonal railway going to give a reply?
But that,
Nearly 3 weeks have passed.
my lord.
Ah.
But I will give them instruction to dispose of as soon as possible.
Because this zonal railway is not a party here, correct?
Not a party, my lord.
My lord, it is on 17/3, my lord, that letter has been issued by the Northern Railway, NF Railway. Until that, my lord, they are not taking virtually any decision, my lord, in this matter.
But my lord, the
My lord,
decision was
yes.
ban- The decision to ban was, my lord, made on 29/10/2021.
Ah.
So, my lord, the important question would be, my lord, when did the petitioner came to know about the fact of banning? And if there was any fraudulent
page 31,
activity
my lord.
involved, whether any FIR was lodged? Whether any FIR was lodged in time?
My lord, page
my lord,
31, my lord, we came to know for the first time, my lord, about this pending.
When?
Page 31, annexure 1.
When? Which date?
17/10/11/22, letter was received by us on 17/11/22. Then only we came to know. Immediately we got to the railway port, my lord.
Then you came in April.
my lord.
You came to this court in
Well,
April.
we have, well, they approached the railway authorities again and again, my lord, and they replied that they are taking into consideration, but they did not do
Let
anything.
the railways come to a final decision before we take a final.
We are unable to, my lord, they file any tender before any other authority, not only railway, my lord, I'm not
We'll
saying.
give you one last chance,
Well,
to,
well,
one last chance.
Well, to take-
We'll give them one last chance, and once if they do not file, if they do not make a decision, we'll decide the matter next week.
My lord, only thing, my lord, what I am submitting, my lord, why I should suffer, my lord, because when Abhijantik was the other partner.
No, we don't know, nah, that is the thing.
No,
You
he has
don't-
admitted, my lord, virtually in that judgment also, your losses.
We do not know, we are not sure, he might have admitted, let this
And
railway come to. Huh?
And NF railway authority also, my lord, that has admitted, my lord. Yes, I know that. Well, that letter your losses will just see, my lord, page 70, last letter. Page 70.
17,
70,
17.
70. And except 16.
Yes,
Last para, your losses may see, my lord. Repression filed letter has been received from the office of the Mrs. Sumkon Adventures LLP for reporting the winning dealing, as they have claimed that never purchased the tender so and so. Now, in response to the clarification sought by the office sent to both Sumkon Adventures LLP and Avijantik, the latter had admitted that the documents used in the said tender are not connected with Mrs. Sumkon Adventures LLP and have not conducted any business with them. Oh, this is their admission, my lord. Mrs. Avijantik Private Limited has lodged a police complaint against forged proprietor. A copy of the NS as per Avijantik, my lord. it has
this
lodged-
is Infratech, you are not Infratech.
No, I have Sumkon, my lord. I have Sumkon. And we have lodged an Jahar, my lord, against FIR against Avijantik. So railway.
You are Infra Ventures.
Yes, we are information. So they have admitted that my documents were forged by them, my lord.
Yes,
And page
Decision has
24
to
is
be
the
taken
Ajahar,
by
my
the
lord.
railway board.
Huh?
Decision has to be taken by the railway board.
this has to,
Ultimately, the railway board has to approve this, my lord. That is why, my lord, the instructions which I have given, my lord. 4 queries were made to all the zonal railway.
but this is by the NF Railway.
Yes,
So,
the
so
decision of banning was taken by the railway board, my lord.
railway
Into
board.
into an order is passed. by
You're
the
not taking a decision. You take a decision.
My lord.
Why are you not taking a decision?
Lord, we will take decision, my lord.
When?
Time may be given, my lord. 10 days time may be given, my lord.
Next week Tuesday,
My lord.
we'll list it next week Tuesday.
My lord.
One last chance.
My lord.
I think. Right. Huh?
Actually, forgery and fraud, my lord, has been committed.
I know, but we'll give them one last chance to take a
Madam.
decision.
Madam.
Third, Shri G.S. Sahewala, learned senior counsel, assisted by Mr. M. Sahewala, learned counsel for the petitioner. The petitioner has challenged the order of blacklisting against a joint venture, namely MS Sumkon Avijantrik bracket JV. First up. The petitioner, that is Sumkon Infra Ventures, Infra or Intra? Infra Ventures LLP.
Yes.
Claim is that it was never a constituent of the joint venture with SM Sumkon Avijantrik. Is it? No, with MS
Yes. Sumkon Avijantik.
Sumkon, no, with MS Avijantrik Infratech,
Infratech Private Limited.
with MS Avijantrik Infratech Limited. Private Limited, Infratech Private Limited. First up. The petitioner's counsel relies upon para 14 of the judgment and order dated 11/4/2023, passed in WPC 7057/2021. In support of his submission that the petitioner did not enter into any joint venture. And that the MS Abhijantrik Infratech so Private Limited had submitted forged documents to enable it to be eligible to submit its bid in response to NIT dated 6/9/2022.
Nine?
Correct?
No,
No, 27/6/19. 27/6/2019.
26.
27/6,
2019.
2019. 27/6/2019. On the other hand, Mr. H. Gupta and CGC submits that the railway board has issued, is it?
Yes.
That the railway board has issued a letter dated 13/4/2023 to the Chief Administrative Officer (CONS) full stop, Northeast Frontier Railway asking him to clarify under which circumstances zonal railway had come to the conclusion for revoking the banning of business against the petitioner, and whether any investigation had been carried out before reaching such a decision against the petitioner. Full stop. The above letter dated 13/4/2023 has been made in pursuance to the letter dated 17/3/2023 issued by the Chief Engineer /CON Roman 5 /NF Railway. Full stop. It is noticed that considerable delay has been made by the Chief Administrative Officer (CONS full stop close Northeast Frontier Railway in making a reply to the Railway Board's letter dated 13/4/2023. Full stop. Last chance is given to the respondents to take a decision in pursuance to the Railway Board letter dated 13/4/2023 addressed to the Chief Administrative Officer (CONS) Northeast Frontier Railway. Full stop. In the event no decision has been made by the Railway Board due to any lapse in replying to the Railway Board's letter by the Northeast Frontier Railway, the matter may be decided on the basis of the materials on report by on the next date. List the matter on
11.
11 of like. Yes, what is this matter?
Here, please, Lords.
Who are you? You are the
I am for the, my lord, the,
applicant or writ petitioner or what?
I am my lord, the respondent in the writ petition, respondent of 4 and 5.
That's what- okay.
And here, my lord, I am the applicant in the stay vacation petition, my lord.
So what is the case of the petitioner?
Petitioner's case is that, my lord, notice has been issued to them by the GMDA
Huh.
to demolish the obstruction they have made to the lift of the flat. Is there, that
How have they made obstruction?
they have blocked the gate of the lift.
How?
They have erected a wall,
Erected a wall.
in the first floor of the flat.
Okay.
They have included it, put it inside their rooms also.
Oh, they made it into a room.
Common areas have also been blocked.
Oh,
Order-
common area has been blocked by them.
Common area has been blocked, the lift has been blocked, and the outer walls of their flat has been demolished, and they have extended to the sunsets and all.
And
Those
it's
are-
extended into the,
To the seats, outer seats. my lord,
Okay,
that is
okay,
there, my lord. So that is the allegation, my lord, main allegation, my lord. That is.
so,
why, my lord, for
so what is their case? What is the petitioner's case in filing the writ petition?
their case is that, my lord, against that we have, my lord, we have initially made an application before in the year 2016, before the GMT for
Ah.
this illegal construction. I am
Ah.
also one of the occupants.
You,
So-
you are in which floor?
I am in the second floor and third floor, my lord.
You're in the second floor and third floor,
Third floor,
and they are in the
first floor.
first floor. Then,
Then, my lord, against that, my lord, when they have started erecting, my lord, we have made application. But no action has been taken by, my lord, GMDA, and time to time, my lord, we have again approached the GMDA also. Finally, my lord, in the year, my lord, 2019, my lord,
but GMD was, I think you're missing something. GMD order date, what is the GMD order date?
GMDA, they ordered
2022.
25, which they have.
Was it based on any other order? Was the GMDA order based on any other order?
There is we have made a complaint before RERA, real estate.
Say that.
Real
Why are you
estate-
missing, why are you missing?
I'm coming to them.
You're coming.
My lord, GMDA.
GMD is a subsequent order.
No, my lord.
RERA, huh?
GMDA is a subsequent order, but initially we have approached GMDA.
Huh.
Then when GMDA has not taken any action, we have approached RERA.
RERA, okay,
We
then,
have made application before RERA.
then what happened?
Then, my lord, initially RERA made a joint inspection of the building with GMDA. They found those illegalities, my lord,
Then?
irregularization.
Was the petitioner present along other? Was he there?
No,
That
we have
no.
made, no.
Then,
We have made the.
then after that, what happened? After that, what happened?
After that, my lord, after the inspection, my lord, when these illegalities and this came out forward, my lord, then finally, my lord, after hearing, my lord, this GMD and all the parties, my lord, RERA has given direction to the GMDA to take action against these illegal constructions.
Which page is the order?
Page 48 of the writ petitioner also.
My lord, the page 127 of my lord, the miss case, my lord, order dated 27/5/2022.
Huh?
Page 127 of my miss case, my lord.
No, the order.
Of RERA, the order of RERA.
RERA, my lord.
Where is
page
the order?
48.
That is the, my lord, order.
What is the order dated?
Order dated, my lord, 27/5/22.
Mr. Congress, you have not read the writ petition. You only
My lord,
consider.
writ petition, my lord.
Look, there is an order of a order passed 1 month earlier
My lord.
in the writ petition. That is of April. You're reading of May.
My lord, the RERA's direction for, my lord, demolition is the page, my lord, 33 of their writ petition. 33,
Page 33.
48, page 48 of my writ petition.
48.
GMDA order refers to this order. Page 48 of my writ petition.
Well, anyway, page 14. We have said page 33.
Here, my lord, different pages.
Which page are you, which page are you talking about?
Page 48, my lord, of the writ petition.
That I've got in front of me.
That is the, my lord, both parties present.
So this is the order.
This is the order, my lord.
Now both the parties present means what?
Both, my lord, the,
Writ petition is also present or what?
no, my lord, no.
Then you come to the GMD order. Where is it? Page?
MD order is that page, my lord.
One point is missing, there is a subsequent order. What you find the subsequent order, dated
No, let us go to the orders one by one. Let us see the first order. Let us see the first order.
there is a subsequent order of the RERA.
The subsequent order. Where is that?
That is order dated 27/5/22.
27,
5/22. That will also will find in page number 128.
128. 128 of the application.
124 of the I.
127 of I.
27 or 20.
127 or 28, what?
127.
127.
My lord, in my I have annexed all the orders passed by RERA and all the orders passed by GMDA. In his
Council,
receipt, my lord, lots
Mr.
of orders.
Council, you have got all the orders. The only problem is I've
My
got to read them.
My lord, they have suppressed several, they have not.
Let
annexed
us
those
see,
orders.
let us see. That's why let us go one by one.
Lord,
I don't have time to go through each and every page of each petition. Seen the petition filed by, you want to see MP Dekha. MP Dekha is the rich district. Both the complainant and respondent present. Okay, respondent is the builder. Okay, then where is the GMD order? Page?
page 49 of the writ petition, my lord. Which they have challenged, my lord. Before that also, there are several orders of GMDA, my lord.
Where is that?
My lord, GMDA has passed this 25222 order. Then on, my lord, 28/7/22, another order, my lord. That is, my lord, page 132 of the IA, my lord.
Yes, that is 132 then.
Then, my lord, there, my lord, before that, my lord, GMDA has passed order on 19/7/21. Then, my lord, 10/8/21. These are, my lord,
Which
annexure,
pages, which
page
pages?
137, 138. Page 137, lordship, page 137 to 141, these are all notices sent by GMDA, madam. 137 to 141, madam. These are several notices Then by my lord GMDA.
130, after that, any other order?
30, then my lord, that is the my lord 138.
Impugned order is at
That is the
138.
138A, my lord. Then my lord, then 139 also, my lord. To Dimpi Deka. Then my lord, 25/8/22 also, my lord. That is 140. Then a page
Which page?
page 140 is also one of the another.
140.
40, my lord. Then 141 also, my lord.
Yes.
So these
So they have made it in the common area.
they have made it in the common area. They have blocked the gate of the lift.
So far as my case is concerned, your lordship, it is not only your lordship, the facts, your lordship, but
We are going to the facts.
no, your lordship,
we are
what I
going-
am praying is your lordship in my writ petition, your lordship. If your lordship comes
You are praying is that you have not been heard.
by RERA, your lordship.
By RERA.
That's all. Your lordship.
Okay, now you are being heard. We are giving you chance to, instead of RERA, you have been giving chance to have a hearing before this court.
Lordship may
Now,
kindly come
before
to-
this court, there's one question I want to ask. Have you built up the area, the common area?
Lordship, no, your lordship.
Where is your
Entire-
agreement? Where is your agreement made with the builder for allotment of the flat?
Lordship,
Is
purchased
it
the-
part of the records?
No, my.
Why haven't you put it? Why
No.
haven't you put that in the records?
The agreement, your lordship.
Yes, we want to see where is the common area, where is, and which is the, whether the lift is to be blocked or not. Let us see that.
Your
You
lordship.
see, if you come hiding facts,
Lots.
I will dismiss it straight away. So please show me the agreement.
Your lordship agreement.
I have doubt that my lord, they have made any agreement between the.
No, that's the agreement about.
Let
that-
us see. They are not coming.
Agreement,
they-
your lordship, I have not annexed, your lordship.
Yes, that's why you
But
have to
your
come with
lordship,
clean
if-
hands.
If your lordship takes up their IA, your
No, no, you just tell me one thing. Can you block a lift? An entrance to a lift?
lordship will kindly see that I have denied that, your lordship. I have purchased the entire first floor, your lordship.
Maybe.
Lordship will kindly note and your lordship will find your lordship.
Where is it in your writ petition that you have stated that there is no common area in the first floor? And that the common area has not been built up. Have you stated that in the?
I
in
have
your-
said, your lordship, that I have not, your lordship, I have not obstructed it, your lordship. That
He has not.
I have
obstruct-
only-
I'm Mr. Counsel, there's a question from the
Lordship.
report to you.
Lordship,
I do not want your explanation. I just want an answer.
lordship,
My question is, I'll put
Lordship.
it down in writing.
lordship.
Where is it in your writ petition
Lordship,
that you have stated that you have not built up the common area
lordship,
and that you have not obstructed entry or exit into the lift?
what I
Lift.
have stated in para 11 is this,
Para
your
11,
lordship. That the petitioner beg to submit that the petitioner has not constructed any illegal construction in the first floor of the apartment, which led to blockade of the entry and exit of the lift and staircase. This is
Okay,
my-
no. Where have you stated they have not built up the common area?
Lordship, common area.
Is
means-
there any common area in the
Yes,
first
your
floor?
lordship, in their IA itself, it will be clear that.
Where is
whatever-
your agreement? Is there any agreement first of all?
Yes, your lordship, we have the agreement probably, but I don't have the copy right now, your lordship. Now, your lordship will kindly, your lordship wanted to know from me whether I have made a specific awareness in my petition that I have not
Page,
blocked.
para.
Para 11, your lordship. The other occupants of the Joshua apartment are enjoying all the rights and privileges, and no person of the said apartment is having any trouble as alleged by respondent number 4 and 5. Moreover, it is a fact that the petitioner has purchased entire first floor and your
Okay,
lordship,
let me see, who is the builder?
lordship,
Where is the agreement made between you and the petitioner?
and one more thing, your lordship. The report was prepared, your lordship, by the, on the instruction of the RERA, your lordship, in which your lordship will go through the annexures, your
He has,
lordship.
RERA
I
has
was
only,
not even present there. No notice was issued to me, your lordship. I have at least, your lordship will kindly see, it is their case in the complaint and even in the IA that this construction is made by the builder
you
itself.
can give a notice now.
Yes,
You
your
give a
lordship.
notice now. Then let the GMD give a notice, that's all.
Well,
RERA or RERA?
Huh?
series of notice has been given to
Say,
them.
No, no,
to
it
the,
is-
to the petitioner.
It is on the instruction of the RERA, your lordship.
From page number, my lord, to 137 to
137.
151. This is the, my lord, this is the series of notice given to, my lord, this petitioner by GMD. Several notices, my lord, even they have appeared before the GMD and they have been heard, my lord.
No, no, not hard.
My lord, this notice, my lord, itself reflects, my lord.
Your lordship will kindly, your lordship will kindly
Just a
come to
minute, just a minute,
page 113 of my, of their IA, your lordship.
just a minute.
Page 113.
Yes, is there any common area in your agreement?
My lord, the area covering the lift area and the staircase, this is the common area.
So have they built up on that area?
I have instruction.
They have instructions.
I'm adding up to that, my lord. What will take up the IA, my lord, page number 130. My, the
No, no, I'm sorry, 138 is a notice given to GP data.
My lord, lordship may come to page 132 on my IA, my lord. 132. Kindly,
Have you, no, just a minute. Mr. Have you given any reply to page 138?
Well-
Yes.
138, your lordship.
Yes.
That is 10-8. Yes, your lordship.
Where is the reply?
That is my, in my writ petition, your lordship.
Oh, you have given a reply. Then you have been heard.
By the ZMD, your lordship, initially.
Yes.
But subsequently, your lordship, the entire matter is taken up by the RERA, your lordship. Now, your lordship will kindly kindly come to,
Page 38.
yes, your lordship will kindly come to page
Okay.
113, your
Just
lordship.
a minute. Page 38 is your reply to this.
Reply, your lordship.
Page 38 of the writ petition.
Writ petition, your lordship.
Page 38 is just this receipt.
No, your lordship, I have annexed that order, not receipt. Your lordship will get it in my writ petition. 18-8, your lordship. Not 38, this is page 45 is the notice, 10-8. And that my reply is at page 46.
Okay.
Now, your lordship will kindly come to page 113 for a moment, your lordship. Now, my reply was given, your lordship, thereafter no process was initiated on the part of the ZMD. Your lordship will kindly come to page 113 of
Yes,
the
I've got.
IA. 113.
Yes, I've got.
Lordship, this is the report, your lordship. On the basis of which your lordship subsequent action on the part of the GMD and the RERA, subsequent orders by the RERA and then GMD were passed, your lordship. Now, in this report, your lordship will find, I am not there, your lordship. This report is prepared, your lordship, in my absence. I am at least entitled to that notice, your lordship. I am not saying that you don't go ahead with that, but at least I am, since it is a, your
Is
lordship,
there?
finding of fact by an authority, your lordship, and in which, your lordship, they are going to demolish something, your lordship, which according to allegedly I have constructed, your lordship. I am at least, when this inquiry was done, this inspection was done, this report was prepared, am I not entitled to any, your lordship, and at least to a notice, your lordship? And when they, your lordship, filed the complaint before the RERA, In that complaint, I was not made a party, your lordship. And their complaint, they said, your lordship, that it was constructed by the builder in collusion with the writ petitioner, your lordship. That is what they have stated in the IA itself, your lord, also, your lordship. Now, whether it is constructed by the builder or by me, if it is constructed by the builder and then handed over to me, your lordship, that finding will have to arrive at, because your lordship, ultimately, if it is demolished and if there is anything on the part of the builder, then I can at least approach for damage, your lordship. Without having that finding, your lordship, certain orders were passed behind my back. And your lordship, inquiry was conducted. What stopped them from making me a party and issuing a notice to me, your lordship, when this inquiry was conducted? Therefore, your lordship, I am not saying, and from the very first day, your lordship, when matter was moved, my prayer was that let me be heard and then dispose of the matter by the RERA, and then GMDA will pass necessary consequential orders, your lordship. That's my case. Limited prayer, your lordship, not more than that.
My lord may come. to
Maybe,
another-
your lordship, that I have, but there will have to be a finding, your lordship, and their own case is that, your lordship, this was constructed by the builder in collusion with the petitioner, your lordship.
Lordship may come
And
to
that too way back in 2016, your lordship.
Page 132, my lord, Annex 23 of my IA, my lord. Page 132. This is the order passed by GMD, my lord. Page 132, Annex 23 of my IA.
Yeah.
This is order dated, my lord, 28/7/22.
Yes, we have been heard. They said we have been heard, but so far as the very basis of these orders, your lordship, when this inspection was made, I was not there, your lordship. No notice was put to me, your lordship. What will happen to that, your lordship? Now, if everybody wants to seek the
You dismantle the thing, they know, why should they target you? Is it your case that, everything as per the plan of the flat?
No, your lordship, that I cannot, ultimately CMDA will decide that, your lordship, whether it is as per the plan or not. But I am only.
When they have decided, then what else remains?
But your lordship, the very basis of that decision, your lordship, then your lordship, I was neither been given any opportunity, your lordship. RERA passed an order where I am not a party, your lordship. Subsequent to RERA's, your lordship, direction, GMDA passed some order and inspection was carried out. There also we have not been heard, your lordship. I am entitled to that much of natural justice, your lordship, to place my case. And your lordship, since 2016 to 2020, this has been going on. If for one more month, your lordship, after hearing me, they can take a decision, your lordship. Heaven will not fall, your lordship. I am being given in your lordship hearing. My prayer is limited to that, your lordship. I am not on facts, your lordship. Whether I have constructed, and according to them, I have not constructed. It is by the builder. And that is in their IA, your lordship. Para 5, the applicant state that in the meanwhile, the builder, opposite party number 5, in collusion with the petitioner along with her husband started. to construct-
Whatever has been done,
Lordship,
the thing is that there has been some construction, that is clear.
lordship,
Your only case is that you have not been heard.
lordship,
That's
that is what your lordship.
all. But
Nothing
then,
more than that.
when the facts are there for all to see, what is the necessity of a notice, whether it causes any prejudice to you? They will have to see that.
Yes,
There-
your lordship.
You see, notice does not have to be issued at all times. And in fact, in this case, you have already been heard. As per the chief executive officer's order, which is not under challenge.
No, your lordship, I have the final order I have put to challenge, your lordship. Ultimately, your
maybe.
lordship, this has been merged with the
Yes.
final order.
Maybe. Yes, anything else? Anything from your side? Let me
My
hear the
therefore
other,
humble
let me hear
prayer
the
is
other
this,
side.
your
I've
lordship.
heard you.
My lord, I am for RERA,
Ah,
respondent 3.
what is
My
your,
lord, this lift lobby,
Huh?
this lift
Lobby.
lobby of the lift,
Huh.
the lift area comes under common area as per the definition of the RERA Act. And that act further states
Which,
that-
what is the act, name of the act?
RERA Act,
RERA Act.
yes, my lord,
Which year?
Real Estate Regulation and Development Act 2016.
2016, which section?
It is in 2N.
2N,
Yes, my lord.
2N.
My lord, may I read the?
Yes, yes.
Yes. Common area means that is in N. I am skipping 1, 2, the staircase, lift staircase and lift lobbies. Fire escapes and common entrances and exits of buildings.
Okay, so it comes under, so this has been built up by
Yes, yes. My
by-
lord,
by-
another section is there, section 17,
section 17.
which states that that comes under the undistributed proportionate share, which cannot be transferred to one single LOT, but to everyone.
Uh-huh. Give me that.
Yes, sir.
Let me see. That's all? Anything else?
Finally, there is another section, section 39. We have not closed that case at RERA. And that 39 Act section further state any agreed person can approach RERA.
Okay, so let him go to RERA then.
He may.
He may go, but then when the writ petition, no case. Yes, Mr. Bora.
What we will turn to, my friend has already shown page number 130, 113.
132,
113, my lord. That is the.
113, yes,
113 of the
113.
I- That is the report, my lord.
Just a minute, 113.
113 of the I.
113. 113 carries on up till which page?
113, my lord.
It carries on till when to the end of.
No, it goes on, the report goes on, my lord. I am only showing the first.
Report.
This is the report of the GMD,
21/9/2020.
inspection report of the GMD.
21/9/2021.
Very first page of page number 113, my lord. Lots will see. See the petitioner has blocked that leaf. This is the photograph of the blocking part, my lord. And in down below, as per approved drawing, there is no any provision of such door and wall.
Correct, correct. No, it's okay. This
It's okay, my lord,
This
everything is
report is
clear, my lord.
made on 21/9/2021. I mean, this report was, I was visited on that day.
Report goes on. It has not been given.
23/9/2021. 23/9/2020. Okay. And she was heard in 2022. Anything else?
That's my lord. Everything is clear, my lord. There is a illegal construction. Not right. That is not compounded.
Yes.
Like, I have handed over the agreement,
Yes.
and the last page of the agreement, your lordship will find that there is a provision for leave. Last page of the agreement.
Last page of the agreement. Building lift. Yes.
The construction of the wall by the builder does not arise.
Construction of the wall.
The wall blocking the lift does not arise from the.
So we'll dispose of the entire writ. You can avail of section 39. I think you know your case very well. Your pleadings clearly show that. You have not, you have nicely skirted that issue.
If your
Okay, in the writ
permits,
petition, huh?
May I leave your Rossif? I have a.
Okay. Heard Mr. S. Bhattakur, learned counsel for the petitioner. Also heard Mr.
You just again.
Who is respond number 1? GMDA. Mr. S. Bora appears for respondent number 1 and 2. Who is 3? Registrar in charge. Mr. P. Goswami appears for respondent number 3. Mr.
User circuit for 4 and 5.
UJ Psyche appears for respondents number 4 and 5. The petitioner is aggrieved with the order dated 2/5/22 issued by the Office of the Guwahati Metropolitan Development Authority. No, issued by Chief Executive Officer, Guwahati Metropolitan Development Authority, bracket GMDA, huh? By which the petitioner has been directed to, the petitioner and one Shri Mrinmoy Barwa have been directed to demolish the non-compoundable unauthorized construction which blocks the entry/exit to the lift in the first floor, comma, in violation of the approved drawing, comma, NOC, and in violation of the provisions of the GMDA Act 1985, comma, the zoning regulations and building bylaws. The petitioner's case is that the aforesaid impugned order dated 2/5/2022 issued by the GMDA has been made by taking into consideration the order dated 26/4/2022 passed by the Real Estate Regulatory Authority, Assam, bracket RERA, in which the petitioner was not made a party. As such, the impugned order dated 2/5/2022, having been made in violations of the principles of natural justice, comma, the said order should be set aside and the petitioner should be given a notice. The action proposed to be taken by the respondent authorities. Next paragraph. Mr. S. Bora. The learned, the learned counsels for the respondents, on the other hand, submit that the petitioner had made an unauthorized construction of the common area of the first floor of the building, thereby blocking the exit and the entry and exit into the lift. That's not into the lift. Steps can go. It's not blocked. Steps are not blocked, no? In a lift, full stop. They submit that they submit that RERA had not made any decision with regard to demolishing the unauthorized construction made by the petitioner and had left the entire issue to be decided by the GMDA, while order dated 27/5/22. Correct?
Correct.
Gustav. They also submit that in terms of section 2 bracket N of the RERA Act, 2016, there cannot be any unauthorized construction on the
Lift lobby.
Huh?
Lift lobby. Lift lobby, Rochip. Common area.
2N.
Common area, my lord.
2N.
2 Roman 2.
2N bracket Roman 2 small, no?
Lift lobby comes under common area.
in the common area
Yes.
for lifts and lift lobbies. They also submit that the agreement made between the petitioner and the builder clearly provides the construction of a lift in the building which has accordingly been built. So they also submit that as per section 39 of the RERA Act 2016, the petitioner has an alternative remedy available if he is aggrieved with the GMDA order dated 2/5/22.
My lord, RERA order.
RERA order dated 27/5/22. 26/4/22 and 27/5/22. And for which the petitioner can approach. For which the petitioner can approach the appellate authority. As provided. It's not an appellate authority.
My lord,
It's not an appellate authority.
it's a regulatory.
What have I said? Just read.
They also submit that as per section 39 of the RERA Act 2016, the petitioner has an alternative remedy available if he is aggrieved with the RERA order dated 26/4/22 and 27/5/22, and for which the petitioner can approach the appellate authority.
For which the petitioner can approach the authority. Under section 39. Have I said that already? Section 39. For which can approach the authority for rectification of any earlier orders made by it. Gustav. The next para, the learned counsel for the respondents also submit that the petitioner submits that the site that the site in issue was visited by a verification team on 21/9/2021 and a report made on 23/9/2021. Stop. The petitioner was also given an opportunity of being heard and was accordingly heard by the officer who signed the impugned order dated 2/5/2022 on 28/7/2022. As the petitioner has been heard prior to the impugned order being issued, there has been no violation of the principles of natural justice. Accordingly, the writ petition should be dismissed as the petitioner has violated the building regulations and built up the common area in the first floor. That's all. Anything else? Nothing else. No? Full stop. I have heard the learned causes for the parties. Full stop. The petitioner's case is that he has bought the entire first floor of the building. Has purchased the entire residential space in the first floor, bearing flat number 1 slash AB capital, huh? In the residential apartment, invert commas, Jasudhara apartment. The petitioner's case is that the impugned order dated 2/5/22 issued by the GMDA has been made by taking into consideration the order dated 26/4/22 passed by RERA, wherein the petitioner was never made a party. As such, comma, the impugned order asking the petitioner to demolish the alleged unauthorized construction in the common area alleged unauthorized construction in the first floor should be set aside. The respondents number 4 and 5 are residents of the same building, but are residents of the same building in the third and second floor respectively. It was on the basis of the complaints made by the respondents number 4 and 5 that the impugned order dated 2/5/22 has been passed by the GMDA. Next paragraph. A perusal of the RERA order dated 26/4/22 and 27/5/22 and 22/6/22 shows that the issue of the illegal construction allegedly done in the first floor, allegedly done in the common area of the first floor, had been considered by RERA. The writ petitioner had also apparently submitted a petition to the town planner GMDA in response to GMDA's notice dated 14/6/22. The RERA wide order dated 22/6/22. Wait, where is that order? They're leaving everything to the stand to be done by GMDA. Where is that order?
No, 27/5/22, madam. Is 127. GMDA
What about 128, page 128? Page 128 is subsequent,
Subsequent,
then
subsequently. 27, GMD shall furnish the action report on the notice number so and so, dated so and so, address to so and so and so and so. It is clarified that GMD must act only as per the GMD Act 1985 and Guwahati Building Bylaws 2014 and other relevant acts and rules on the complaint filed by the complainants in the case.
what have I said?
The writ petitioner has also apparently submitted a petition to the town planner GMDA in response to the GMD notice dated 14/6/22.
The order dated 22/6/22 issued by RERA thereafter. And that necessary action should be taken by the GMDA after hearing the writ petitioner. The next para, the report. Made by the report dated 23/9/2021. Made by the GMDA and RERA pertaining to the unauthorized construction. Is to the effect that unauthorized walls and doors had been made by the petitioner. In the first floor. The petitioner was also given an opportunity of being, was also heard by the Chief Executive Officer, GMDA. As can be seen in the order dated 28/7/22. Wherein it was stated that Sri Minmoy Borwa and Mrs. Dimpi Deka are directed under section 88 of the GMDA Act 1985 to dismantle the barrier/obstructions made at entry and exit to the lift at first floor and make it accessible to all as common area, by dismantling all kinds of barrier/obstructions erected, within 10 days from the date of receipt of the order dated 28/7/20. And as per the earlier order passed by the GMDA on 2/5/20. On perusing the writ petition, and on perusing the application made in IA number 783 of 2023 by the respondent number
4 and 5.
by respondent number 4 or 5. It is quite clear that the petition had been made aware of the complaint regarding construction of regarding unauthorized construction of the common area, thereby closing the entry and exit to the lift. Full stop. The petitioner was also heard by the competent authority prior to issuing the impugned order for 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 demolishing the unauthorized construction. Gustav. It is also seen that the petitioner had made a reply dated 18/8/2021 to the show cause notice issued. No, show cause notice dated 10/8/2021 issued to the rate petitioner under section 87 and 88 of the GMDA Act, 1985. In view of the above facts, it is clear that there has been no violation of the principles of the actual justice. The writ petition being devoid of merit is hereby dismissed. The interim order passed earlier stands vacated. When you say in view of the order passed in the main writ petition, the interim application also stands disposed of accordingly.
May I please your lordship? May I please your lordship?
Yes,
Lordship, this is a case of fair price shop, my lord. Like, my license was cancelled because of some allegation. Let me see, NHR 1. My lord, notice was issued for violation, which is a notice was issued by the superintendent of food, my lord. And then a reply was also made to that superintendent in Annexure 2, my lord.
Huh?
In Annexure 1, a notice the notice which has been issued to me regarding some misappropriation of food items and commodities were done, that was issued against me, for which a reply was also made by myself to the.
yes,
superintendent.
yes. What?
We have filed an affidavit.
You file affidavit?
Yes.
To what effect?
That my lord, after getting complaint, my lord, notice was issued to her, and after inquiry, her license has been cancelled.
My lord,
In fact, my lord,
Or where's the proof?
yes,
Where's the proof that, show me,
my lord, if my lord may see in page number
due to
23.
misappropriation of NFSA rice. Now, where is the proof? Is there any document to prove it?
inquiry was conducted, my lord.
Huh?
Inquiry was conducted, my lord.
Yes, inquiry was conducted, but then show us where is the inquiry report?
Yes, my lord.
Where is the evidence that he has done something wrong?
Yes, my lord. It is not annexed, my lord, in the affidavit, my lord.
Lord, these
In fact, my lord,
complaints they have
I
made,
just
my
wanted
lord,
to know-
are constantly vague, my lord. And because.
Where is the records? You bring the records,
The record is not with my lord.
huh?
Record is not with me.
You bring the records. Look, when you say that he has done some misappropriation
Yes, sir.
of what? Of the rice
Yes, my lord.
and other commodities.
Yes.
Where is the proof? You have got to show the proof. It must be in the records that this much kg was supposed to be disbursed. Only this much has been disbursed or something to that effect.
Yes, my lord. We have to go through the record, my lord.
My lord, if my lord may hear me,
Kindly look at annexure 6, page number 20.
No, Mr. Council, there's no point saying anything now without the record.
MLA is involved and using his political connections, my lord.
Maybe, why not? MLAs, why shouldn't they not be involved? They are for their work, they are for the people.
They are means they are recommending other persons, my lord.
Maybe, we do not know. We do not know. Yes, you're supposed to bring the records as per the order
Yes, sir.
dated 14/9/22.
We have not received report, my lord.
Huh?
Sometime may kindly be entered.
Mr.
And Satya, my lord.
M. Chutia, Learned Counsel for the Food and Civil Supplies
Yes, ma'am.
and Consumer Affairs Department is to produce the records in terms of the order dated
Records.
14/9/22. Huh?
My lord, records were asked to be produced on 14/9/22.
That's what I've said. 14/9/22. I'll list the matter. When? Give a date.
3 weeks, my lord.
Give a date.
My lord, any short date, man.
Next.
My lord, there is the same subject matter, the item number 27, the subject matter is same, my lord.
So the records again. Give me item 27. Same order, same order. Same order.
Yes, sir.
Pleasure, pleasure.
My lord will take this matter for disposal today. Very short matter, my lord. The issue involves non-payment of contractual bill of supplies, my lord.
Ah.
Now, my lord, during this pendency also, we have released some amount. It's an admitted amount that admitted that they have supplied the material. We have received. So, my lord, only my prayer is that, my lord will dispose it with the direction to the authorities to verify the amount, only the amount. I'm not about the goods. Goods we have admitted. Only there are 5
If the goods are admitted, what is to be verified?
verified means who will get how much amount, my lord.
Who will take how much amount?
Means it's a big, my lord, thing, amount contract, few crores. So there are 5 writ petitioners, different writ petitioners. So even they also.
Look, your submission is that you are not denying that contract or the supply order was issued.
We have
They have supplied the materials. You have accepted,
accepted.
and so there is nothing short, no short supply. And only thing now is payment of
Payment,
then.
in between we have released payment also.
Ah.
Part payment we have.
Okay, so just to verify how much has been released
Balance
and
amount.
give the balance amount.
And my lord will grant us 4 months time to complete this payment.
Everything is admitted, lordship. I have nothing to say on that, my lord.
So he
Because
wants,
They have released us 2 installments also. So only thing is that they have to pay the.
so he says
remaining-
that
remaining
he
balance.
should be given 4 months time. What do you say?
But not on that, my lord, 3 months.
My lord,
My submission that much, I
I-
am praying for 1 month.
my lord,
Yes, my
that
lord,
is my
that much.
instruction, my lord, because it's more than 10 crore. The,
Maybe, but when did you ask them to supply?
no, my lord, the thing is that
2015,
my,
2015.
Ah.
my lord, there was a lot of dispute in between. The high power committee was brought in for this. Lot of verification went in. My lord, so my lord, he is telling his prayer is 3 months, my lord. I am praying for 4 months. That's it, my lord. I'm leaving it to you. Means, my lord, I don't want that they should come again for contempt. My lord, I want that they should get the payment, my lord. That's why I'm to be in a safer side. My lord, my prayer is 4 months.
Okay, right. Heard Mr. UJ Sakya. Learned counsel for the petitioners. Wait. In all the cases, okay, for all the petitioners. Also heard Mr. Ardhar. Learned
Standing counsel.
standing counsel handloom, textile and sericulture departments. Appearing for the respondent number 1 and 3.
He is for finance.
Full stop. Mr. H. Aliha appears for the finance department. Full stop. This batch of writ petitions are being disposed of by this common order, as the subject matter in issue is the same in all the above cases. Full stop. Next para. The case of the petitioners is that they had been issued supply orders by the respondent authorities for supplying materials. Materials where, what materials?
Well, the yarn and blankets,
For supply of,
yarn and blankets.
there have been materials, that is yarn and blankets. In pursuant to tender notices. Different tender notices.
No, tender notice dated 30/10/2015.
In terms of tender notice dated
30/10/2015.
30/10/2015. Full stop. In the case of the petitioners is that though they had made the supply of the materials to the respondent authorities in the year 2000,
Well, the 15 itself.
in the year 2015, comma, the respondent authorities had not made payment of the bill amount submitted by the petitioners.
No, we have made full payment.
As submitted by the petitioners, had not made the payment of the entire bill amount. Full stop. Next para. Mr. Ardhar, learned counsel, no, Mr. Ardhar and Mr. Ardhar, learned counsel for the respondents number 1 and 2. Submit
1 and 3.
that the petitioners have made supplies of the materials as required under the NIT dated fields. And full stop. The respondent authorities have also accepted the said materials. He submits that he submits that though the petitioners have been paid payments of their bills in 2 installments, comma, the entire bill amount has not been paid to the petitioners. Full stop. He submits that the state respondents may be given 4 months' time to clear the outstanding bill amount of the petitioners after verification of the amount that is still due to the petitioners. Full stop. Next, on considering the submissions made by the counsels for the parties. Just before that, you just said the Mr. UJ Saikya, learned counsel for the petitioners, submits that the petitioners may be submits that the respondents may be directed to clear the outstanding bill amounts within 3 months and not 4 months. Full stop. I have heard the learned counsels for the parties. Full stop. On, in view of the submissions made by the counsels for the parties, it is clear that the respondents have admitted that the petitioners have supplied all the materials that were required to be supplied in terms of the NIT dated so and so. Full stop. It is also admitted by the state respondents that they have not cleared the entire bill amount of the petitioners, which also goes to show that they have admitted their liabilities towards the petitioners in terms of the NIT dated so and so. Full stop. In view of the fact that some payments have been made to the petitioners, the state respondents are directed to verify the actual outstanding amounts still payable to the petitioners after deducting the payments already made and make payments of the same to the petitioners within a period of 4 months from today. What? From today. 4 months to be counted from today. Huh? The writ petitions are accordingly disposed of.
My lord, only one point, my lord, we are the allotee given security money, registration fees, everything. And it's honorable, but directed them to put us in possessions and they took time, my lord, and still there's no possession. We are waiting, my lord. That's
Initially, my lord, I am not putting their claim, my lord. They are entitled to, initially it was occupied during the COVID, some other person occupied. In the meantime, we have evicted them. Now that area is kept blank, my lord. In the meantime, you are making the process to allot those persons who are entitled to. That's why post it after 2 weeks, my, in the meantime, the process.
Mr. Council, this thing you have already stated earlier
Yes,
also.
the process is on, my lord.
Huh?
The process is on, my lord.
Process
Because
is on, but then how many months it was this
only another 2 weeks, lordship, we'll do it, my lord.
another 2 weeks?
No,
They can start. My lord,
Huh?
they-
Another 2 weeks, my lord, we'll complete the process, my lord, because this 81%.
You will complete the process of allotting them their original site.
Yeah, lordship, but in the meantime, some other person has entered.
Correct, but you have evicted them already.
Lordship, we evicted.
You have evicted them in January.
Lordship,
Now it's May.
Lordship, we allow 1 2 weeks time, and in the process is going on, my lord. We'll verify, they have to verify those persons, those 81% and everything has to be done.
allotment
Unless-
letter, everything is there with them. They can start from tomorrow only and in the meantime, they will,
That's why, my lord,
completion report may be.
They will give you 10 days time to complete.
that will give another 4 days, my lord, 4 weeks, 2 weeks. Another 4 days, 2 weeks time, my lord.
We'll give you just 2 weeks. We'll fix a date.
Lordship.
We'll fix a
They
date.
may start, my lord, completion report may be submitted. Because
Yes,
these are
yes.
with-
Right. Mr. S. Bora, the learned counsel for the GMC, submits that steps are being taken to give possession of the area. It's not shops. No, those are not shops.
Open space.
Steps are being taken to give possession of the open area
Yeah.
to the petitioners as the unauthorized persons have been evicted. He submits that the entire process would be completed within 2 weeks. First up, accordingly, list this matter, give 2 weeks, exactly after 2 weeks,
Lordship will be in the May 16th, my lord.
16th.
The completion report may be submitted.
Completion report will be submitted on the next date.
Obliged.
Wait with the lordship. Look at the theatre reinspection was ordered. And I pray for 2 months more time to complete the reinspection of this project.
500 projects are there.
This biogas plants were installed in several hill districts, including Kabe Anglam. And some disputes are going on and the Honorable Court has permitted us go for inspection. It requires lordship another,
Inspection for what?
the installation of the projects. Petitioners allotted 500 projects for installation of 500 biogas projects. It's a central government's project, lordship. It is executed through IIT Guwahati. We have selected.
So these biogas plants were constructed when? Which year?
Work order was issued in 2017. Pursuant to it, we have completed the construction and in the year 2019, we have also got the work completion certificate by respondent 1. Thereafter, when this sanctioned amount has to be released by the ministry, they have come up with some irregularity that we have committed during the construction. Now, a verification has to be done to that effect. The last order 23-1 to 2023 indicated by this honorable court, that is 6 weeks inspection has to be completed within the 6
Have you started? What is the status of your inspection?
Lordship.
What is the status of your
No, that-
re-inspection?
We shall be requiring some.
Huh?
It's money is to be sanctioned by the central government. It's money problem is solved. And several departments are involved here, including Government of Assam and Forest Department. I think it will be.
What is this circular dated 13/12/2020?
My lord,
Two.
that is, my lord, fine.
The induction, what's will be completed in
Page
2 months.
116 to 124.
100
16 to 124.
116.
116.
I don't have 116.
My lord, this is an affidavit in opposition filed by respondent.
Ignorant, ignorant.
117, my lord, will find that circular,
Yes,
pursuant to which clause 4, they have said that a re-verification has to be committed.
117 clause 4. What does it say?
My lord, may we kindly.
118 in my
120, page 120.
This is a fresh reinspection
Fresh
report.
re-inspection. This is at the time when the payment has to be sanctioned from the ministry, my lord. Work completion has been done. My lord, the IDs may also be required to. get
Yes,
the-
you tell me, reinspection, how much have you done as on date?
No, Lord, we are going to start it now only because money problem is just means settled. The inspection will.
Mr.
involve-
Council, the money problem is secondary.
No.
Now you have got to do the reinspection.
Lord, we
The
will-
reinspection of not the money. You're not going to reinspect the money.
Lord,
You're going to reinspect the biogas plant.
because all entire district you have to cover.
Maybe,
Check
but
every-
you had been given time
No, that-
in January 2023.
so some
Now,
more
what
time
have
will
you
be-
done for the last 4 months?
That's it, because for petitioner's interest, Lord, it has been done. Then
It,
we-
it is, but he has already done it in 2019.
No.
Now it is 4 years have gone.
There's a big fraud played upon it. You have come to know, central government is it. That is, it is all 500 projects. These are not newly installed. It's the old project. They have decorated it, then said you have done it. That was the game, Lord. So that are detected by the central government recently. Then now they directed us to inspect every 500 projects in all hill areas. That will be taking some time, some money also. It has come,
No,
Lord,
you
so
see,
we
that
will
is
complete it.
okay. We have given you time, but then
Some more time will be given, Lord. What I
how much
interest-
time? How much time?
2 months more time, Lord.
No, too much.
6 weeks, Lord, because all hill areas to be covered and they have to go
My
and
lord,
check
as
and
of the date,
You
I
have-
have been termed NPA in the DRT because of this cases, my lord. I've taken note
only
for this
time, Lord,
project.
that's it.
My house has been put on.
6
auction,
weeks
my
time we
lord,
will
twice.
complete it, Lordship. 6 weeks. After that, we'll leave the matter to your Lordship.
Right. Mr.
My lord.
Mr.
Jason,
Jason
Jason.
appears for the petitioner. For the petitioner. And Mr.
RP Kapati, Lordship.
RP Kakati appears
For
for
1 to 4, Lordship.
1 to 4. Anybody else? No. Mr. K. Gogoi appears for 5 and 6. Full stop. The counsel for the senior counsel for the respondent number 1 to 4 prays for a further 6 weeks time to reinspect the matter in terms of the letter dated 13/12/2022 issued by the Ministry of New and Renewable Energy, bracket Biogas Division, page 118 of the writ petition, huh? Full stop. He submits that if the respondents do not complete the reinspection within the said 6 weeks period, this court may pass orders at its discretion. Full stop. On considering the prayer made by the learned senior counsel for the respondents number 1 to 4, a further 6 weeks time is provided to the respondent authorities to reinspect the biogas plants in terms of the letter dated 13/12/2022 issued by the Ministry of New and Renewable Energy, bracket Biogas Division. At least the matter, give a date,
My lord,
give a date, 6 weeks.
my lord, I will clear that the petitioner may also be allowed to participate in this investigation because he
That-
knows
that-
where
that
the.
is there.
GPS plant and biogas-
The respondent shall also allow the petitioner to participate in the reinspection.
My lord,
of the
six
biogas
weeks
plant.
Later date may be given. My lord, this case has come out to 14 weeks from 23/1, my lord.
We have given a date.
16. Obliged.
Obliged, Lordship.
1 minute. Just one.
Okay, six.
Because in this case, we are directed to produce records, my lord. We have called for the records, my lord. We have not received the same, my lord. Kindly some more time.
Records were called for, but
When did you bring the records? When did you bring the records?
Kindly 2 weeks, my lord. We have already communicated, my lord, but we have not received, my lord.
first order is of 33, Lord.
Huh?
Order is of 38 of March to call for a record.
Mr.
M. Setia, my lord.
M. Chetia,
Yes, my lord.
learned counsel for the,
Junior government advocate.
for which respondent?
Yes, my lord. Respondent, my lord. Respondent 2, 3, my lord. And 1, 2, and 3, my lord.
4 and 5 also, Lord. Municipal board is 4 and 5. And record is from municipal board only.
And I pay for the 5, my lord.
You are for which respondents?
1, 2, 3, and 5, my lord.
1, 2, 3, and 5.
Well.
Golpara Municipal Board, what about that?
It is represented by executive officer, my lord.
Huh?
Represented by executive officer, my lord. I can take also notice for respondent 4 also, my lord.
4 also.
Yes.
Who is for 6 and 7?
Town and country planning.
District Development Council and Deputy Director, Town and Council, Government Advocate probably. Lord.
Yes, my lord. 6, 7, my lord.
6 and 7 also.
Yes.
What is this? Mr. M. Chetia appearing for the respondent's number. What about 8, 9? Yeah, Mr. Gogoi, you are appearing for whom? 8 and 9? Okay, Mr. M. Chetia appearing for, huh? 8. Okay. Mr. M. Chetia appearing for respondents number 1 to 7
And 9 also, Lord. 9 can.
and 9.
Deputy Commissioner.
No, that is finds the cause of deputy commissioner. That cannot be.
Yes.
You are appearing for 1, 2.
1 to 7 and 9, my lord.
So 3 also you are appearing. Deputy commissioner also.
Yes, my lord.
So that means 9 also you can appear, deputy commissioner.
Yes, my lord.
Okay, 1 to 7, 9
9.
and 9. Please for how much time to produce the records?
2 weeks, my lord.
Please for 2 weeks time to produce the record.
From Golpara Municipal Board also. That may be mentioned.
To produce the records from the Golpara Municipal Board. To stop. Mr. B. Gogoi appears for respondent number 8. Any private respondents?
I'm appearing for 10, 12, 13, 14, 15.
Mr.
AK Gupta.
Appears for the respondents number
10, 12, 13, 14, 15.
10, 12, 13, 14, 15. This is a matter after 2 weeks to enable Mr. M. Chetia to produce the records.
Lots of date may be fixed.
You were date.
Lots of.
This is a matter, my lord. The petitioner, my lord, transported, my lord, some chips, stone chips. In the vehicle, my lord. And those stone chips were seized, my lord, by the police officer. My lord, if your losses come to my lord, the petitioner purchased, they are the minor minerals. Stones are minor minerals, my lord, and they purchased it from the miners, my lord.
From the mines.
Miners.
Miners.
Mines the, my lord, final minute.
Stone chips from the miners.
Leaseholder. Leaseholder of the mines. These are given to the, my lord,
Mines don't produce stone chips.
No, stone, my lord, stone.
They'll produce stones, not chips.
No, not chips, stones.
Stones. You say that, you said stone chips.
They
That's right.
purchase the stones, my lord, if your losses come to, my lord.
And stones also are not produced from mines, actually, they are made by stone crushers usually.
Yes, stone cutter. I have a stone cutter also, my lord.
So, you've got a stone crusher.
Yes, I have a stone cutter, and cast it and then send it, my lord.
So you buy rocks, that means.
I buy rocks.
You buy rocks.
Yeah.
And the rocks, you make it into stone chips. You crush them.
Yes, and
Yeah.
then sell it, my lord, if your losses will see, my lord, that, page 51, and it's a 6 series, my lord.
Page 51.
It's,
Yes.
these are the, my lord, the memos by which, my lord, we purchase those rocks, stone gravel, my lord.
Arshing.
Arsing is the myself, my lord,
Ah.
I the consignee, and the consignor is, my lord, Indra Subba.
Indra Subha. Okay.
He's the Mahaldar.
Okay. So you have bought it from him.
Yes, from him, my lord, these are the seven, I thought. Now,
You
after-
have bought stone gravel.
yes. It's not gravel, it is called gravel also, my lord, boulder also. Now, after crushing those, my lord, stone. Now, after crushing, my lord, in the crusher, my lord, it will also.
You see, the problem is,
Yes.
if you buy a stone gravel,
Yes.
then there's no need of crushing stone gravel. They're already crushed.
No, not crush, my lord.
Huh?
These are big size.
Big size.
Big size.
Big size, how big?
My lord, it may be 2 feet, 1 feet, my lord, 1 feet,
1 feet will be called a stone.
1 feet, 6 inch, this type.
Okay.
Yes.
Then,
My lord, now if your losses come to page 57, my lord,
57, yes.
57, my lord, these are the series, my lord, I have one I have shown. This is, my lord, my Aksa stone mill, my lord, that is the stone crusher. There we have crushed it, and then after charging, my lord, the CGST and SGST, so we prepare the, my lord, tax invoice and send it to other persons.
RK Stone Mills, who's the owner of this?
My lord, this is Rakesh Singh. I am the.
You're the owner.
Then, my lord, these facts were detained by the first authorities, my lord, in Vancouver. So, after, in detention, my lord, we have issued a letter, my lord, to them, page 59, my lord. We have issued a letter that this is illegally you have done, so please read the vehicle immediately.
Rakesh. just put it up.
Annexure 9, 8 and 9, my lord, these are two letters issued. Only by saying, my lord, that you have illegally detained those vehicles. So please read it. Along with that. This is page 60 also same, my lord, almost same letter. Yes.
Yes, then
Then, my lord, you issued another letter, my lord, which is at page 60, same, my lord, not saying, my lord.
page.
Page 60, because another vehicle is there,
Yes.
so we have issued similar letter. Now, my lord, they have served a copy of the notice on the driver, that is at page 62. You are hereby called upon to produce legality and proof of origin of forest produce as per provisions of the rules, regulations having force of law, loaded in track number so and so, seized so and so, on so and so under some 49 of the Assam Forest Amendment Ordinance and rules made under section 40 of the Transit Rules and Assam Forest Regulation 1891, entitled thereto 30 days from the date of issue of this notice to the undersigned so and so for you. So this notice has been issued, my lord, to the driver. Similar notice has been issued.
Notice dated?
My lord, these are the 13/7, my lord, 22. They have not given the date, but 13/7/22, my lord. The original one, we have noted the date, my lord, page 63. They have not given any date, my lord. But we have received it on 13/7/22. Similarly, for another track, my lord, another notice has been given on the same date to the driver. Now, my lord, your lawsuit shall come to page 66. This is the main part. Now, page 66 is the vehicle seizure penalty ticket, if your lord will see. Here, what they have said, price of the minor minerals. Your lordship got it, my lord?
Yes.
10,200. Royalty, 1,700. GST, 595. Income tax. Well, I do not understand well how they can. Fine amount, 50,000. Processing fee, 310. So they demanded, my lord, 53,000 and all. This is a minor mineral, my lord, and they are charging. This is the penalty of 50,000, my lord. Similarly, my lord, another vehicle also same, my lord, that page 67. Same thing, my lord, which we have challenged here, my lord.
Okay.
In this matter, my lord,
So what is the ground of challenge?
my lord, challenge is, my lord, this is because this is a minor mineral, my lord, we can transport it anywhere. They have no right to, my lord.
There is no prohibition on transportation of minor.
Minor mineral, my lord.
And what is their case?
My lord. Yes, my lord. The affidavit file, my lord. Here, my lord, what happened on the interim order was passed, my lord, for release of the vehicle on the furnishing of a, my lord, the bond, my lord. The vehicles only, my lord, the stone is still lying with them. The vehicles were by interim order released to us on execution of, my lord.
Now what do you want?
Now, my lord, the entire matter,
You want to set aside this order?
yes, the two, my lord,
66 and 67.
yes, my lord. 66 and 67, these are to be passed, my lord.
On the ground that these are minor minerals
Yes.
and they can be, such penalty cannot be imposed upon them.
My lord.
Under what law?
Under the
Minor Minerals
minor
Act.
mineral rules, my lord,
Rules.
under that, my lord, they have imposed this. Now, if your lawsuit comes to, my lord,
What are the rules? Where is the minor mineral? What is the
Yes.
name of the rule?
I'm giving you. Hello, I am giving a punch, my lord, I shall produce these, only extract has been given, my lord, here.
What is the name of the rules?
Rules, my lord, it is called, some minor mineral rules, my lord.
Assam minor mineral rules or regulations.
No, rules, no, 2013. Mineral concession rules, 2013. My lord, this is.
Yes.
Now, my lord, rule 63 and
Yes.
64, my lord, this is in respect of illegal mining.
Yes.
Nothing more than that. Now, if the lordship will find, my lord, that after 3 pages, my lord, schedule X, my lord, and schedule Y is there, my lord. After 3 pages. my lord.
After 3 pages.
Yeah, my lord. Schedule X and schedule Y is there, my lord.
Yes.
Schedule X, my lord, it is minor minerals, my lord, building stone and so and so. So these X item, my lord, these are to be dealt by forest department. These can be, my lord, dealt by forest department. And the other, my lord, the minor minerals, Y, X is by the, my lord, the mining department. X only can be dealt by the mining department.
By the mining
Mining
department.
department, my lord. And why, my lord, these materials, these can be dealt by forest department. As per rule 3. That rule, my lord, your losses may just.
There is
be-
no why.
My lord, why is there, my lord? Next page, after X, my lord. After X, there is a Y.
After X,
Yes.
there is no why, not in my copy at least.
Oh, why? No, I'm just. I'm sorry.
X. Ah, no, it is there, it is there. I've got it. Why, huh.
And these things, your loss will find that rule 3, my lord. Just before that, I have given to your losses, my lord. Minor mineral rules, my lord, that
So gravel is here, gravel.
yes.
Gravel is to be dealt by by forest
Forest
department.
department. That is to be dealt by forest department. And your loss, that your loss will file in rule 3, my lord. I have given just, my lord, the first, your losses may take up the rules, my lord. Rule 3, your loss.
Yes,
A mining lead, mining contract or permit or any other concession or license or transit pass, permit or license or control of regulation of mining or other action under the rules shall be granted and taken by the director in respect of minor minerals for the industrial and specific uses specified in Schedule X. You have also got it, my lord. And the principal chief conservator of forest and head of the forest Assam or any officer authorized by the government by notification in his behalf in respect to the minor minerals for uses other than industry in the Schedule Y. So for this, my lord, these so far stone materials are concerned, these, my lord, forest can deal with. my lord. Now, if you also see, my lord, they are affidavit, my lord.
no, what is your case? This is gravel. According to you, gravel can be dealt with by the forest department.
Forest department can be dealt with it. I'm not on that, my lord, but this is minor mineral.
Minor mineral.
Minor mineral. So they cannot put any restriction in the, my lord, movement of the minor mineral.
Where
I'm coming to
where
that.
is that? You see, out here it says.
Yes.
If Schedule Y.
Yes.
Is to be dealt with by the forest department. And if that minor mineral is gravel, when you read it with rule 3,
Yes.
rule 3 provides that a mining lease or a mining contract or permit or any other concession or license or transit pass or permit so and so shall be granted by the principal chief conservator of forest and head of forest Assam
Yes.
or any other officer authorized by the government by notification in this respect,
Well,
in respect of the minor minerals.
Minor.
Now, do you have any transit pass issued by the PCCF
my lord,
for that gravel?
so far this is concerned,
Huh?
this minor mineral does not require any transit pass.
But just now you
My lord,
you're the one who has shown me
Only
this.
thing, my lord, that has been given, my lord, saying that, my lord, that is there. But if you also see, my lord, that the Mines and Minerals Act, my lord, there is no transit pass.
But just now you are the one who has shown
Only
me this
they can
provision.
deal with, my lord, the granting of lease or license.
No. Look, look, you see, when you say transit pass,
my lord.
transit pass is for basically for movement. Now, if gravel is to be dealt with by the forest department, that is under Schedule Y. And when the rule says that transit pass is to be issued by the PCCF, do you have the transit pass?
My lord, I am coming to the, my lord,
Oh,
I am coming, my lord, because that is not required, my lord.
that is
Because
not required.
that is, yes.
So, but this rule says otherwise.
No, rules, my lord, only, my lord, that in the definition, my lord, we have given, but the Mines and Minerals Act does not provide for that. Mines and Minerals,
Then what is this rules that you have
Mines
given?
and Minerals rules,
Rule.
concession rule, but that has been enacted under the Mines and Minerals Act, my lord. That is the
But
central
then
act.
the rules is the rules helps in the implementation of the act.
My lord, in fact, it has been interpreted by our High Court also, that no transit pass is required, my lord. So,
That no
transit pass is required.
transit pass is required. No transit pass is required.
Right.
So that means that this rule,
Only to that extent, my
But-
lord, because so far the granting of lease license is on the forest department. So far, the Y items are concerned. Y items are concerned, like Schedule Y. And Schedule X, my lord, is the mineral department which can grant lease or license.
no, that is for operating, but transit pass, now when is transit pass issued? Transit pass issued for
Transit pass
movement,
is under Forest Act, my lord, not under the Mines and Minerals Act.
then this is under the Assam minor mineral possession rules.
That word has been mentioned, but that is not required, my lord. That's been just
Okay, I don't know. I don't know, because I don't know.
that's correct.
When the rule says,
Yes.
when the rule says that it is required, can we say it is not required?
My lord, when the parent act
Under
says,
the rules are
no,
challenged.
when parent act says, my lord.
Huh?
Parent act says,
So you mean the rules are ultra virus the act?
well, so far, that word only is concerned, my lord, that is, my lord. Here, my lord, if you also see. This word transit pass, my lord, that is all, that is not required, my lord. So far, because
That
this
is not required.
no, this is in meant for all the minor minerals, not only the.
Let us see the act.
Yes,
There is the act.
my lord. Mines and Minerals Development and Regulation Act 1957.
Does Assam have a separate act?
No.
No.
Section 15 is the power, my lord, to make rules in respect to mining. The state government may, by notification of the official gazette, make rules for regulating the grant of quarry leases, mining leases, or other mineral concessions in respect of minor minerals and for the purposes connected there. You'll also notice section 15, my lord.
Yes.
The state government may, by notification of the official gazette, make rules for regulating grant of quarry leases, mining leases, or other mineral concessions in respect of minor minerals and for the purposes connected there. In particular, and not prejudice to general province power, such power shall provide for any of the following, namely, the person whom and manner in which application for quarry leases, mining leases, other mineral concession may be made, and a fee to be paid so and so, time within which and form under which, my lord, these are same thing, my lord, only the grant of quarry lease, mining lease, other mineral concession. If you also see, my lord, everything is in respect of this. So this is the rule, my lord, framed under this section, my lord. Minor mineral concession rules. 2003.
though nothing is stated, but then the rules by the Assam government, made by the Assam government provides for transport, provides for issuance of a transit pass.
Transit pass, my lord, no rule, my. No rule is there.
No, the rule is there.
No, this is only, my lord, that word has been used here,
Yeah.
except that nothing is there, my lord.
Correct, but then once it is used, can we turn a blind eye
I'm
to it?
coming, my lord, to that also, my lord.
Okay, then-
Because this section 15 does not, my lord, deal with the transit.
Transit, does not do.
This is only in respect of mining, my lord.
You see, but the problem is this.
Yes.
Problem is this. I think you know this much better than me. Forget about a rule,
Yes,
even any executive instruction.
Yes.
Or any, say, any order
Yes.
made by a government,
Yes.
made by the government.
my lord.
It is a valid order. Until and unless it is withdrawn by them, cancelled or struck down by the court.
My lord.
Similarly here, when there is a rule providing for transit pass,
My lord.
can we immediately say that it is an illegal, it is void or it is a void?
I'm coming to Supreme Court this also.
We'll go to that, but I want to know on this point,
My lord.
not
Yes.
on the other point, on the point of whether when there is something written in the rules, a
Well-
statutory rule, when something is written,
Section 25.
whether you can turn a blind eye to it
My lord.
and say that, no, that is a void
But this is, my lord.
wording put there.
My lord, the section 23C has been elected by the, my lord, in the act, my lord. That
Section
is Section 23C.
23C.
My lord.
Twenty-three C.
My lord, section 15 is only for the purpose of, my lord, my,
Yes, 23C, yes.
power of the state government to make rules for preventing illegal mining, transportation and storage of mineral. Here, the state government may by notification of the official gazette make rules for preventing illegal mining, transportation and storage of minerals for the purpose connected therewith. So, my lord, this is in respect of illegal mining only,
Transportation,
transportation of illegal mining.
not illegal mining, comma,
Comma, but
transportation
That is the, my lord,
and storage of minerals.
that is correct, my lord, that is for illegal mining only.
And for the purposes connected therewith.
Yes, this is only for illegal mining, not for regular mining, my lord. If it is validly, my lord, extracted the mineral once, there is no power in the act, my lord, that it can be prevented from transport or doing anything on that.
No, illegal mining, transportation.
This is interpreted by Supreme Court, my lord.
Then we'll see, we'll come to that.
Yes. Now, before that, my lord, your lordship must just see the affidavit, their affidavit,
Huh.
their affidavit.
Yes,
There are 5, my lord, your lordship may come.
yes.
My lord, here they have annexed, my lord, notification of 2003, my lord, that also we have challenged in other case. Stone crusher units are governed by notification number so and so, which provides no stone crusher unit installation will be installed without obtaining a permit from the government or forest department. Under the aforesaid notification license, the permits is constituted where the representative from the all regulatory authority, including representative of the deputy commissioner of the district concerned included. Main stakeholder in this context is Department of Forest, since stone is a minor mineral under some minor mineral rules. Now, there are 6, my lord. There are 6, the last 2 sentences, your lordship. My lord. Yes, para 7 might come out. Para 7, next page. That in the instant case, on 8/7/22, staff of the Jaipur Forest Range apprehended the vehicles in question, 1 truck and 1 dumper, carrying stones, and the driver of the vehicles were asked to produce requisite documents, transit challans, which are mandatory while carrying minor minerals, but they failed to produce any such document or challan as mandated by AMC rules 2013 and a notification of 2003. As such, the offense was registered in the names of the driver respective vehicles, to which driver pleaded guilty and agreed to compounding offences available under AMC rules. Now, there are 8 members. The deponent file states that penalty tickets were issued against the minor mineral found to be without requisite papers, and such penalty tickets were raised online for compounding the offences as mandated by AMC rules 213. More particularly, rule 64(1) of the AMC rules that vehicles can be released only after realization of the payment or the payment of price of minor minerals and applicable royalty for the minerals extracted, and the fine shall not be less than 10,000 rupees. The petitioner had agitates the issue of issuance of improper forms of notices and seizure list, which is however irrelevant for offences that are registered under AMC rules and not under Assam Forest Regulation. And compounding has been reported under AMC rules 213, not under Assam Forest Regulation, which provides a seizure and confiscation and notice condition precedent to such confiscation, whereas in the present case, compounding has been resorted to by payment of fine. So under Mala rules, 2013 rules, they have issued those penalty tickets, my lord. So these are the minor minerals, and under this, my lord, they have done it. Now, if your lordship will see, my lord, I'm placing, my lord, 2 judgments, one of our high court. Thank you, sir. Thank you. Thank you, sir. Thank you, sir. Huh? My lord, I shall place para 12 onwards, my lord.
Para?
Para 12 onwards.
Wait, what is this?
The contention of Mr. Bora is that Multan Sukla, the effect.
No, wait. Let us see what is the question to be decided in this case. Let us go to
Well, para 2.
para 3.
Yes.
The basic challenge.
For transit pass and transit challan under the provisions of section 40 of the Assam Forest Regulation.
Under the Assam Forest Regulation, but the issue here is different. Issue out here is under the Assam Minor Mineral Act. Or rules, by the Assam Minor Mineral Rules.
That was the coming, but we have lost it, my lord.
No, but where out here the issue is different.
No, here.
Out here is under the Assam Forest Regulation.
My lord, that is under, the ticket has been given. My lord. That was it. Now, my lord, your losses may just see, my lord, here, because they are saying that 2003 notification has been given that the Stone Casa unit require my lord, the license from the forest department. And they are, my lord, in that 2003 notification, it provided transit pass and transit challan.
What 2003 notification?
They have annexed with the affidavit of opposition. That is under challenge in the other case, my lord. 2003 notice. And this was also, my lord, subject matter of that case also. Which I.
No, whatever it may be,
Yes.
mentioning of or non-mentioning of the provision of law does not render the order invalid.
Right.
When there is a provision for exercising such a power.
Then, my lord, your losses may just come directly to the Supreme Court judgment. 2019, 16 SCC, 513.
So this judgment is not in
No,
your
it
favor.
will be required, my lord, that we have lost.
It's not applicable.
No, effective, my lord.
How is it applicable? You
Effective,
show me
yeah,
first. Let's not jump to the
No, no.
other writ petition,
No,
to the
but-
other order. And let us first confine ourselves with this order, then we'll go to the next. You bring that.
Yes.
You show me how this judgment pertains to the Assam Minor Minerals Rules.
My lord, this is in respect of, because they have said, my lord, the 2003 notification, they say that Stone Casa unit requires a license. In the next case, directly we have challenged it.
No,
that-
I'm not on that. Let us be very clear.
Yes.
Is there this case, the Guwahati High Court on judgment pertain to the Assam minor mineral rules.
Transit challan and transit pass, my lord.
Transit challenge and transit path, but it does not pertain to the mineral
My lord, it says, my lord, that-
minor
no,
minerals.
in this case, it has been said that stone is a minor mineral.
It's a, then,
That it is not
then
a. my lord,
that
one
is not
second.
in your favor.
No.
It doesn't support your case.
Your losses may just take the man Supreme Court.
Huh?
Supreme Court judgment.
Supreme Court judgment.
My lord. Your losses, my lord. My lord. This is against the Gujarat High Court judgment, my lord.
Let us see what is the issue to be decided in this
Yes,
case.
yes. My lord, the issues are, my lord, at the para 34. Para 34. Your losses got in, my lord. From the subject matter of the appeals as well as argument, it clearly follows that the main issues arise for.
Para 13,
34.
30, huh?
34.
Yes.
From the subject matter of the appeals as well as arguments, it clearly follows that the main issue that arise for constitutional art, whether the impugn rules framed by the state of Gujarat as a delegate to parliament are beyond the powers granted under it under MMDR Act. In other words, whether impugn rules are ultravirus to section 15, 15A, 23C of the MMDR Act. This is directly, my lord.
So this out here, there was a challenge to the rules.
Yes, that is regarding transit, my lord.
Huh?
Whether the impugn rules are violated, my lord, these are regarding transit, my lord.
Huh?
Regarding transit, my lord. If you're also.
Regarding,
Transit.
regarding what?
Transit, my lord.
Transit path.
Transit.
Transit path
Transit
of
of the
sand,
product.
but it is with regard to sand.
Sand.
It is not with regard to stones.
My lord, other, my lord, yes. Oh, may not be, my lord, but minor minerals.
Okay, for minor mineral.
Minor minerals. Now, if you'll also see, my lord, the
So out here, the
34
challenge was to the,
whether
uh,
impugn rules are
to
violated
the
of part-
MMDR Act.
this is minor
And
mineral
no,
development and
No,
regulation.
no, whether the rules are ultra virus,
My lord.
whether the impugned rules are ultra virus.
Yes.
So out here, the rules were challenged. But
May-
out here, the rules are not challenged. So
But-
can you take away the judgment passed in some other case, in some other state act, state rules, and put it here when no challenge is made to the Assam rules?
My lord, what I am submitting, my lord, that this rule has been framed under section 15 of the MMDR Act. This is the rule.
Hmm.
This is not under 23.
Yeah.
23C is different, my lord, subsequently it becomes.
Hmm.
So under 15, my lord, the rule empowers the state government only regarding granting of lease, license or concession in respect of mines.
No,
Not
I
other thing.
understand, but
Not-
let us
not-
see your prayer.
Not
there.
other thing.
Let us see your prayer.
Yes.
What is your prayer?
Here, my lord, here. Page 30. No, 29, 28. Page 27 almost.
You have not made a challenge to the rules.
No, here not, in the second case, it is there, my lord.
Hmm?
Well, no, rules, we are not telling.
Then,
Rules we are not
but what,
telling.
but it is still there in the
No, no,
rule.
no. They are only, my lord, the definition, they have what you can, my lord. Except that nowhere it is used. And no permit provided, nothing is there.
But then it is there in the rules. What can we turn a blind eye to it? That's what I'm asking you. The issue is if there is something written in the rules, can I say that what is written in the rules has to be, it's it's not relevant?
My lord, here they are not saying, if my lord, regarding, if you also see, they power exercise under this, my lord.
You see, I understand, just correct me if I'm wrong.
my lord,
The thing is that I understand the case in a certain kind of way. Only problem is what is provided in the rules. That transit pass, that word is provided in the rules. Now, can we, as students of law, say that what is written in the rules, that is of no relevance, that you just turn a blind eye to it. Since it is not provided in the act.
No,
That
in
can
the
it be?
rules also, in the rules also, nowhere my lord, it is provided that they have to issue transit pass.
No, let us see.
Nah, except that section 3, rule 3. Except rule 3, nothing is there.
Then that.
No, but the subsequently, my lord, there must be, my lord. Subsequently, nothing is there, my lord.
But maybe subsequently, but it is there at the end of it.
My lord.
It is still there.
No, but this has been interpreted by the Supreme Court, my lord.
Let us see the interpretation, but not maybe with regard to some other rule of some other state, not with regard to the Assam state mining rules.
No, wait, my lord. My humble submission is this, my lord, because the entry tickets were issued under the MMC rules, my lord. MMC rules, the entry tickets, what they have submitted, my lord, they say, my lord, price of minor mineral.
Okay, then where are page 34 then?
My lord,
34,
35C, my lord. The
35.
appellants have submitted the section 15 gives the power. Subsection 1, section 15, state government may make rules for regulating of grant of query leases, mining leases and other concessions in respect of minor minerals and for purposes connected therein. This power of regulation pertains to granting of leases. It is submitted of Mr. Kapoor that expression regulating is the widest amplitude and would therefore confer power to make rules of the nature made herein. He has referred to various judgments of this court wherein expression regulating has been explained. He has also submitted that any case, section 15(1)(a), such power is there and provision has to be read independent of section 15(1). It is difficult to accept the aforesaid contention in view of the judgments of this court in so and so. In those judgments, it has been categorically held that power of the state government under section 15 of the MDR Act does not include control over minor minerals after they are excavated. My lord, that is directly, my lord, on this. After they are excavated, the following observations from the said judgment are expected herein. The High Court quashed Rule 8B, D, and 19B, principally on the ground that Section 15 of the Act gives power to the state government to frame rules to regulate internal and foreign trade in granite. It has after been queried. Section 15 does not empower a state government to frame rules to enable state government or company or corporation to fix minimum price for granite. The Learned Council of Appellants submitted that Rule 8D and 19B were valid having regard to the preamble to the said Act, and Section 18 thereof submitted the rulemaking power of the state under Section 15 is wide enough to encompass Rule 8B and 19B. The said Act enacted to provide regulation of mines. Well, this is important. The development of minerals under the control of the union. Section 2 of the said Act declares that the expedient in the public interest that the union should take over its control regulation of mines and development of minerals to the extent provided in the said Act. Section 13 empowers the central government to make rules for regulating grant of prospective licenses and mineral leases in respect of minerals and for the purposes connected therein. Subsection 1, Section 15 empowers the state government to make rules for regulating grant of quarry lease, mining lease, and other mineral concessions in respect of minor minerals and for the purposes connected therein. Subsection 1A of Section 50 states that whom and the manner in which an application for quarry lease, mining lease, or like may be made and fees to be paid therefore. The time and form in which the application is to be made, the matters which are considered where applications in respect of same are received on the same day. The terms and conditions in which fees may be granted or regulated, the procedure in this behalf, the facility to be afforded to leaseholders, the fixation and collection of rent and other charges, the time within which they are payable, protection of rights of the third party, protection of flora, and the manner in which the leases may be transferred, construction, maintenance, and use of roads power transmission on the road, the form of register to maintain reports and statements to be submitted to whom, and a revision of any order passed by the authority under rules. Well, this is my lord. Now, if your lordship will see, my lord, further. Next, my lord, para 24 of this, my lord, next page is sub-para, my lord. There is no power conferred upon the state government under said act to exercise control over minor minerals after they have been activated. The power of the state government as subordinate rulemaking authority is restricted in the manner set out in section 15. The power to control the sale and the sale price for the minor minerals is not covered by the terms of clause O of subsection 1A of section 15. This clause can relate only to the regulation of the grant of query and mining leases and other mineral concession, and it does not confer the power to regulate the sale already made minor mineral. So, my lord, this is there is no, my lord, power on the state government, my lord. Once minor mineral is accepted, nothing is there. Now, my lord. (47). Likewise, the condition of license granted by the state of Kerala to affect that it could be sold only in the state. That too, for domestic and agricultural purposes was struck down with the following words. The appellants complain that certain conditions in the form of restrictions has been incorporated while issuing licenses. One of such conditions which the appellant attack is that minor minerals to be stocked where they were purchased only from the authorized quarrying permit holders on their behalf. Another condition is that they are permitted to sell the minerals only within the state of Kerala. That too for domestic and agricultural purposes. The appellants complain that is the far two corporate societies are concerned. They are not settled with any such restriction imposed in the case of the appellant. Thus, according to the appellants, there is a clear distinction between the corporate society and the individual. The matter of restriction imposed in the license granted to them. Apart from this, there is no legal sanction for such restriction. Now, my lord, your losses may come to para 40 to 43. The transport, my lord, regarding that. On the other hand, prohibition on the transport and sale already mined minerals outside the state has no nexus with the object and purpose of the entire act is concerned with the conversion and prudent exploitation of minerals. In so far, section 23 of the MMDR Act is concerned, well, this is important. It was inserted by 1999 Amendment Act with the objective to prevent illegal mining. That clearly spelled out that in the statement of objection reasons, we may reproduce that portion thereof. A new provision proposed to be inserted in the Act prohibiting transportation or storage of anything, and storage or anything causing transportation or storage of any mineral except under the new provisions of the Act with a view to preventing illegal mining. Further, the Act is proposed to be amended to cover the breach of the provisions of the proposed new provision of the Act to be punishable. It is also proposed to insert a new provision to provide for anything seized under the Act as liable for confiscation under court orders. A new section is proposed to be inserted to empower the state government to make rules for preventing illegal mining, transportation, and storage of minerals for the purposes connected therewith. It is thus in this context, the transportation and storage in section 23 are to be interpreted. Here, the two words used in the context of illegal mining, it is clear that it is transportation and storage of illegal mining and not of the mining of minor minerals like sand, which is legal, backed by duly granted license, which can be regulated under this provision. This is, because transportation was only illegal mining. Therefore, no power flows from this provision to make rules for regulating transportation of legally extracted minerals. As per the issue B is concerned, we are also concerned the opinion that impute rules are violative of the Constitution to the effect that thereof. To further the freedom of trade, commerce, and intercourse under section 321 of the Constitution, and the article of freedom must be with the expression for the territory of India. Under 302, Parliament may impose restriction on freedom of trade and commerce and intercourse between Israel and Israel. Well, so this is the Supreme Court has interpreted section 15 deals with only mining, granting of lease, license, and concession of a mining. And section 23C is only in respect of illegal mining, not for legal mining. There can be no restriction, my lord, for transportation of legal mining. But this is the, my lord, what I am expecting. So, so far legal mining is concerned, my lord, they cannot impose any restriction. And what, my lord, I wanted to place there for High Court judgment is also there, my lord. That judgment also, my lord, say that some paragraphs, my lord, and I just. Thank you. Thank you. Okay. My lord, in that our Guwahati High Court judgment, my lord, a few paragraphs are also see, my lord. Paragraph 10 onwards. The principal secretary. Principal Secretary Forest by notification number so indicated above certain guidelines for installation of stone crushing machine identified as stone crusher. In the state laid down therein the procedure to be followed to obtain such permit for installation of stone crusher machine. While issuing such guidelines indicated in clause 17, it provided that stone entering and leaving the premises stone crusher unit shall be governed by PP and transit challan to be issued by such provisions of the rule. Therefore,
As provisions of the rules, which rules?
Madam, a rule, madam, there will transit rule.
Huh?
Transit rule under 45.
Transit
no,
rules.
In this notification itself.
Assam Forest Regulation.
Assam person.
And under the Assam Forest Regulation.
Therefore, in order
So
to
this
attract
is
the
a
provision-
different issue. Assam Forest Regulation.
But in order to attack the provisions of clause 17 of the aforesaid notification, the item in question, the stone must fall within the definition of first produce. The learned counsel for the petitioner referring to the definition of first produce and provisions of section 3(4)(b)(4) submit that stone is not not to be found in the definition, although the work rock and minerals have been mentioned therein. It is also contended that the query as to whether stone falls within the definition of first produce or not came up for consideration in apex court in the case of divisional first officer South Kamrup versus Guwahati and others, Mulchan Taraugi, 1971. Apex court in the case of it is difficult to hold that stone is a forest produce with the meaning of tag. The aforesaid decision of apex court placed into service for consideration before the division bench of this court in Bedlam NT versus State of Assam, 1982 Guwahati. The division bench referring to the decision of the Mulchan Taraugi entirely held that. Next question, whether stone is a forest produce.
But that is not an issue here.
My lord, they are, my lord, raising this issue.
That is an issue because in item number 15, my lord, they have challenged our guideline for stone crushing unit on the ground that stone is not a forest.
In item number 15.
15, 14, 15, 16 Clark, my lord.
Well, all the three cases are
In
here.
15 and 16, they have challenged the guideline for stone crushing unit. That is, I have annexed in this affidavit, my lord.
Okay, so
the ground that's-
14 is different, 15 and 16 is different.
Actually, my lord, 15 should have been the leading case, my lord, because
So,
15.
my lord, the three cases are interlinked, my lord, actually.
No, but right now we are on 14. 14 is only with regard to the trucks carrying
My lord.
this, the stone chip.
My lord.
And so that is different. The stone crushing unit is a different
But-
issue altogether.
My lord.
We have to delink those two, I think. Because it
so
will,
now
there'll be a,
No.
because stone crushing unit as far as I know right now,
Yes.
your case is that stone chips come under the provisions of the minor mineral act and
Minor-
rules. So we accept that. This court accepts that. Now, the judgment that you are relying upon
Yes.
is with regard to the whether stone is comes under the Assam forest produce. So that is a different issue.
My lord.
That is a different issue. So I do not know how this
No.
judgment is going to
Anyway,
have
my
any
lord,
relevance
No,
to the facts.
for
in
the
the
present, I am not placing it, my
Huh?
lord. For the present case, I am not placing it.
Ah.
But I shall not quote it. I
Ah.
shall come for 59.
Okay.
But-
So for item 14
Yes.
is only with the issue as to whether a transit pass is necessary for transportation of those.
And
Okay.
whether, my lord, the authorities under the Mines and Minerals Regulation and Development Act can impose any restriction in transportation of minor minerals. In transportation of minor minerals, because Supreme Court has said, my lord.
No, no, I understand.
So,
Only problem that this court is finding difficult
my lord,
with your submission
Yes.
is that you have not made any challenge to the rules.
rule. My lord, here, my lord, what happened, my lord? They are issuing the, my lord, your lordship will see that two tickets, my lord, penalty tickets, which we have, my lord, challenge here, my lord. They have, my lord, imposed royalty, GST, income tax, fine, everything, my lord. Under rules, whether they are entitled to this.
That is okay, a different issue. That is a different issue.
That is the thing, my lord. Here, my lord, that is the only question, my lord.
Whether you can impose income tax,
My lord, GST, royalty, GST,
income tax, GST, royalty
and fine.
and fine.
Fine, as well as, my lord, minor minerals price also.
Minor minerals price, what do you
But
mean?
they are realizing this minor price of the minor mineral.
Minor minerals price. We'll have to see as per the rules.
So when it's a legal mining, my lord, once we have purchased the stone, my lord, from the holder, my lord, of license, so there is nothing illegal, my lord. So they cannot issue these, my lord, or this ticket, my lord. If you also see page 66 of the petition, my lord. Page 66. Where is the power, my lord, on the of the forest department, my lord, to issue such, my lord, in respect of minor? You are also seeing, my lord. Price of minor mineral, 10,200. Royalty, 1,700. GST, 595. IT. Then fine amount is 50,000 and processing fee is 300. Now they are coming to 63,000. This is absolutely on the face of it illegal, my lord.
Okay, I think I've heard you. We'll hear the other side now. Yes.
Madam, only issue is that, madam, if the petitioner has, madam, legally, validly procured the minor mineral, this notification, this demand notice would not have come, madam. He has to just show, petitioner has to show that it was legally purchased from a legally leased mine, madam. That he has failed.
No, he has said that he has purchased it from this person.
Yes, let that be produced, madam. Where is that, madam? I don't see any document.
No, where is that, where is that?
Page 51 onwards, my lord. Annexure 6 series.
Madam, if I may take your lordship.
Page 51 onwards.
Yes, page 50, and my lord will kindly see.
Hmm.
It's a transit pass. They themselves are saying transit pass is not required for the purpose of this case, my lord.
Ah.
My lord will see it was valid, first line, my lord. Date and time of dispatch, 23/2, valid up to 23/2.
Yes.
Dates are relevant, my lord. Then, my lord, next document, my lord, page 52, same transit pass. 14/2, valid to 14/2. Then 4/5, next page, my lord, issued on 4/5, valid till 5/5. Then 9/5, 5/5, 9/5. Then, my lord, will see 11/5, valid for a day only, my lord. 14/5, 14/5, single day validity, my lord.
Ah.
Now, my lord, it is their own case. It was truck was seized on 8/7. There is not a single transit pass for 8/7, my lord. Let that be produced. We'll withdraw and we'll recall the order, my lord. They're showing some other purchase documents to make good their case here, my lord. It was all passes are valid for a day. The truck was seized on 8/7/2022. There is no document to indicate that on 8/7/2022, the vehicle was carrying a legally mined stone, my lord, against the transit pass. Now they are even saying that transit pass is not required. This is a case which can be decided on facts. That is why, my lord, we ask them.
No, the transit pass is required.
Transit pass
As
is
of
required,
now.
my lord.
No, okay, so now transit pass is required, supposing. Now, the second part of his argument is, how can you impose income tax, GST, royalty, fine, etc.? Where is the provision
My lord, that
for
specific instruction I
exercising
have to
such a
take.
power?
For the purpose of, my lord, royalty, my lord, I have a notification of the government of 2017.
Okay, for royalty, all right. What about for the others?
I'm coming to you. Basically, the justification for the breakups, my lord.
Yes,
Direct specific instruction to that effect I do not have today, but my lord, let me try once from the rules itself. My lord, Rule 64, my lord, because the petitioner has failed to indicate procurement document. So for us, it's a part of illegal mining,
no, it's okay, but then when you're going to impose some penalty,
my lord.
it
That is
has
where-
to be, it has to have some source of
Yes,
power.
yes, sir. Perhaps Rule 64 of my lord, some minor mineral concession rule 2013, my lord.
Just a minute. This is for what? This document is for
Royalty, my lord, to be paid.
royalty. Royalty you have given, you have said 1,700. It says out here 500 per
Part,
truck.
part, my lord. It may be, my lord, letter than enhance also, I don't know.
Maybe, but then this is what you have given me.
Yes, my lord, but it is.
Now,
I'm
we
not on the quantum,
cannot decide a case on maybe.
I'm not on quantum, my lord, I'm on the authority, my lord. That we can impose royalty.
Correct, but then you see,
Quantum is justified.
quantum also has to be justifiable.
Because that was never their pre-death case, my lord. It was all along that was case that it is not required. So that's why to that specific, my lord, I don't have any, even in the affidavit also, we have not indicated that. That I will come, my lord will kindly come to pay to Rule 64, my lord,
Rule
of the
64.
concession rules 2013, my lord.
Yes,
My lord, Rule 64 says, any act of illegal or unauthorized mining shall be liable to the following. For a first time violation, the said mineral shall be liable to be seized along with the impounding of all such tools, equipments, vehicles, and or any other things used for such unauthorized operation, which may be released only upon realization of the payment of price of the mineral. Mineral price is here, my lord, and the applicable royalty for the mineral extracted, and in addition, a fine which shall not be less than 10,000 rupees. So IT and other thing, my lord, I have to take instruction. Secondly, my lord, if my lord peruses the affidavit filed by the state, my lord, it is an admitted position of fact that the petitioner operates a stone crusher unit. Stone crusher unit, it's not a stone quarry. They bring stone from the quarries, that is their case, and crushes in their machine, my lord. So there is a government, my lord, notification of 2003, page 76, the affidavit filed by the state, my lord.
yes,
Page 76, Annexure A, my lord.
yes,
The governor of, it is the 29th of January 2003.
yes.
The governor of Assam is pleased to issue guidelines for installation of a stone crusher and crushing machine. Identified as stone crusher within the state, consequent on the issuance of guidelines on no consequent on the issuance of the guidelines, no stone crusher shall be installed in the state without obtaining a permit from the government in the forest department. If my lord comes to clause 17, page 9 and 77.
Yes,
Any clause 17, my lord, any type of stone entering or leaving the premises of the stone crusher unit shall be governed by transit pass and transit challan duly issued under provisions of rules. That is Rule 40 of transit rules, Assam Forest Regulation. Stone crushers are, my lord, operated under the license.
but we are not under the forest regulation. If you come under the forest regulation, then stone is not a forest
No,
produce.
that has been now, my lord, our apex court has clearly held, my lord.
Acha,
Not
it's
even
a
stone, my
subsequent
lord.
judgment.
Not even stone, my lord, my lord, the pieces of stone after crust remain stone, my lord, and it's a forest produce.
Where is that judgment?
My lord, if my lord, item number 15 of the written.
Acha, it's a judgment when passed recently.
That is famous judgment, my lord. Just a minute.
Okay, now the only issue is with regard to the penalty,
Yes.
income tax. I
Then
don't think you've got any power under the income tax act.
my lord, may post it tomorrow, my lord. I'll take specific, that's for 2 minutes, my lord. It will take, my lord, I'll take specific instruction.
Because you see, this 17 can also can be read in terms with Rule 3 of the rules.
My lord, exactly. And my lord, in that case, my lord, the issue was whether upon promulgation of MMDR Act in 1957, my lord, whether the Indian Forest Act or the Perimeter Assam Forest Regulation will survive or not. Because apparently in certain situations, it is seen that there are incidental encroachment. The Honorable Apex Court has held that both act will run. It is for the purpose of regulation of mines, other is for the, as a forest produce, my lord.
Anyway, so
My lord, I post it tomorrow, my lord, I'll justify the breakups, man, try.
tomorrow is motion day.
Any day, my lord, day after, any day, my lord. As per your lordship. my lord.
Okay, right. Huh?
15 and 16. Item 16, in which I appear, your lordships, which my learned friend has just been apprising your lordships, is relating in regards to a stone quarry which now is shut in terms of a notification that has been a show cause notice which has been issued in terms of the notification which my learned friend has just now relied on in 2003.
The guideline of stone crusher.
The guidelines.
That is
So
under
our
seven.
case is that under 63, 64, in which the notice has been issued, the show cause notice is not maintainable Kwame, because I'm buying it from a permit holder whose royalty has already been paid.
Paid.
So that, if your
So that
lordships
will
are
not
hearing
be
together, then
applicable.
we would like to be heard together. Otherwise, if your lordships are dealing it as your lordships had requested in the beginning, then it can be kept otherwise, whatever your lordships.
So we'll delink your case, I think.
No, I'm also appealing, my lord.
In 15, he's appearing also.
My lord.
Because I think 15 and 16 is slightly different.
Yes.
From 14.
Yes.
Out here 14 is with
But,
regard to
uh,
transportation per se.
Yes,
Yes.
It's not with
It's
regard
not
to
a
the stone
question of
crusher.
law, my lord.
yes.
So stone crusher issue, we can decide it separately.
My lord.
We can, but let me pass the order with respect
I
to
was just indicating
14.
that 16 and 15 are related to the stone quarry. So that could be heard.
So far, this budget case is also concerned, my lord, that
Huh?
what is has seen, my lord, that the transit word has been used in the rule, my lord, that your lordship has seen. That may be, my lord, from the query to the other place, not otherwise, my lord, because Supreme Court has clearly said that no
Is
restriction
there-
can be
there-
put.
There is no restriction on the word.
Because under the. We have to.
Yes, it could. be.
But we have to be satisfied that, my lord, that this stone is procured legally after payment of MMDR royalty, my lord.
Because,
That is why these passes are insisted, my lord.
because we have already, my lord, the Mahaldar has already, taken, but.
Yes, he has to
telling that-
indicate from which mahal he has procured, my lord. We will verify, that's all. That they are
Selling
not
the, my lord,
indicating, my lord.
they have taken the royalty. They have only taken the royalty, my lord.
No, anyway, I'm not disposing of the matter. I'm just going to record your submissions
My lord,
so that we can dispose it off on the next day.
my lord.
We have heard you for so long. Let us at least pass the order. Right. Heard Mr. J.S. Sahewala, the senior counsel for the petitioners, as well as Mr. P.N. Goswami, learned additionally
My lord,
for the state.
all the state respondents. All the-
Appearing for all the states. The grievance of the petitioner is that the state respondents have seized the two trucks belonging to the petitioner, which were carrying stones, stone chips or what?
Front chips.
Were carrying stone chips without having any powers to seize the said trucks in terms of the Assam Minor Mineral Concession Rules 2013. The petitioner's counsel submits that in terms of the hereinafter referred to as the 2013 rules. No? He submits that in terms of the 2013 rules, he submits that though Rule 3 of the 2013 rules provides for issuing a transit pass by the Principal Chief Conservator of Forest and Head of Forest Force, Assam, in respect of minor minerals specified in Schedule Y, which includes gravel, that is stone chips, the said use of the word inverted commas transit pass cannot be applied to the, cannot be applied for seizing the trucks of the petitioner, as the minor minerals bracket development and regulation bracket close Act 1957 does not provide for issuance of a transit pass. Full stop. Hereinafter referred to as the 1957 Act. Full stop. He further submits that in the judgment of the apex court, in the case of state of Gujarat and others versus Jayesh reported in 2019, 16 SCC 513, rules made by arrangement, rules made by a state government under the 1957 Act, made under Section 15 of the 1957 Act. Can relate only to the regulation of grant of quarry and mining leases and other mineral concessions. And it does not confer the power to regulate the sale and transportation of already mined minor minerals. Full stop. He further submits that in terms of the judgment of this court in so and so versus so and so versus so and so reported in 2009 3 GLR 586, stone does not fall within the definition of forest produce. And as such, the authorities cannot insist for a transit pass under the provisions of the Assam Forest Regulation for transportation of the same. No. That's your case. Anything else?
Yes, seizure has been done
First
under
up.
forest also.
He submits that the seizure has been done under
Under the section 40 of the transit rule and Assam Forest Regulation Act.
under section 40 of the
Transit rules
transit rules,
under Assam Forest Regulation.
under the
Assam Forest Regulation,
and under the Assam Forest Regulation
1891.
1890 rules 1891.
No, Assam Forest Regulation 1891.
Assam Forest Regulation 1891. So he also submits that vehicle seizure penalty ticket has been issued against the two seized trucks, wherein the penalty imposed upon the petitioner provides for price of minor minerals, number one, price of minor minerals, one. Number two, royalty. Number three, GST. Number four, IT, IT bracket 2.55%, right close. Then number five, fine amount. And number six, processing fee. The petitioner's counsel submits that the respondents would have to show the power in existence to enable them to exercise, to inflict such penalty upon the petition. Next para. Mr. P. N. Goswami, the learned additional AG submits that stone is a forest produce in terms of the judgment of the apex court in the case of
State of Uttarakhand versus Kumau stone crusher.
Mount Stone Crusher, reported in.
Reported in 2018, volume 14 SCC 537.
He also submits that
Under Rule 64, my lord,
under Rule 64
of the minor mineral concession rules 2013,
of the 2013 rules,
department is empowered to, my lord,
the department is empowered to realize payment of price of the minor mineral, the applicable royalty, and a fine not less than 10,000 rupees for the illegal
or unauthorized mining.
or unauthorized mining. But out here, there is the question of mining.
That is what I'm saying, my lord. If he could produce, my lord, from where it has procured,
He submits that unless the petitioner is able to produce
the source of procurement.
the source of procurement of the stone gravel, the
Seized by
petitioner would be deemed to have illegally and unauthorizedly mined the said stone. Cease. Full stop. He also submits that the penalty for transportation of minor mineral I don't think this is applicable. Is governed by the notification dated 6/3/2017.
Not minor mineral, it is forest produce, my lord.
No, it says transportation timber, non-timber, forest produce and minor minerals.
That's the amount of royalty actually prevailing at that point.
But it says they are entering Assam
Yes, they say,
through interstate boundaries
they have said,
from neighboring states.
they have said in this petition that they have procured it from Arunachal Pradesh.
Anyway, Mr. P. N. Goswami submits that he will obtain instructions with regard to the source of power for levying income tax and GST.
And yes,
And GST. List the matter thereafter. That is for item 14, huh? Item 15, 16, we'll fix it some other day.
my lord.
Maybe day after tomorrow, my lord.
Maybe along with this case,
Okay.
on the same
We
day,
just say, the item 14, 15, 15, 16, is dealing this case from this item 14, huh? Dealing this case from the above case and list it again day after tomorrow.
Now, my lord, there is another matter, my lord, your notice may just say, WPC 6603 of 21. 1921. Huh? 19.
With regard to what?
My lord, this is also minor mineral, my lord. That I think.
Let this be, it'll be a problem. Let it be like this. We take it up. It will be confusing otherwise.
so it is posted day after tomorrow, my
Definitely.
lord. Deeply aware.
which was seized from a person to whom I
Just
have
a minute.
given-
They don't know how to.
not getting comfortable.
Just a minute. No, no. They put the question the wrong way. Yes.
My lord, the vehicle of the petitioner was given on rent to some particular person who is also driver, my lord. Thereafter, my lord, in violation of my terms and condition,
No, no. What is this? This is regarding?
relating to the release of the vehicle which has been seized by custom authority.
Okay.
I have given a list of my vehicle, my lord, annexure 2, my lord. That for a period of 11 months, he has to give me per month 50,000 and he has to apply the legal goods as per the provisions of law. In the meantime, my lord, the vehicle was caught with a cigarette, my lord, foreign made cigarette. Then, my lord, the seizure list and show cause was issued, my lord. I have apprised to the authority that the provisional release be given to me. Then, my lord, they passed the 2 impugn orders. First said the court office will deal with the matter. Then, my lord, ultimately rejected my claim, my lord. Seeking, my lord, provisional jimma. They have passed 2 impugn orders, which is, and no order actually has been issued, my lord. Only way of communication that your lordship will see, page 119 and 120.
Yes, madam.
Lordship, I am appearing on behalf of my senior Kasikyal. He is in leg, let him continue in between him.
119.
190.
Let us wait for him. Otherwise, no
For
point.
my lord, maybe fix some other day. I have to visit hospital, my lord, at 3 o'clock. Any day, my lord, since he is not there, lordship fix the matter any other day.
Okay, but
Maybe
on the
Monday.
prayer for adjournment made by Mr. J. Barbuya.
I have not made adjournment, my lord.
No, because he said he's coming.
Lordship. Instead of my lord seeking adjournment, simply my lord. Otherwise, I am also answerable to my.
No, no, because you want to
Yes,
go to
yes.
hospital, that's why.
Yes, lordship.
And on the prayer for adjournment made by Mr. J. Barbuya, who submits that he has to visit, he has to go to the hospital, this is the matter. When?
Any day, your lordship.
After a week,
Lordship. 2 weeks.
2 weeks.
1 week, 2 week, any day, lordship.
It depends upon you.
1 week.
You want 1 week, 2 weeks, anything.
Lordship. May please, your lordship. My lord,
What is your case?
My lord, this is a case about
Disqualification.
disqualification.
So are you filing any affidavit or what?
Actually, the affidavit is more required from the state side, the deputy commissioner, because the order that has been challenged is the order that has been passed by the deputy commissioner.
Yes.
Yes, my lord, we have not received any instruction, my lord. Some time required for taking.
my lord, may I renew my lordship prayer for interim relief, lordship, as on 9/1/2023, lordship. Your lordship may kindly see the order of 9/1/2023, lordship, the first order, lordship. Wherein while issuing notice, lordship, this honorable court granted me the lordship liberty to pay the interim relief if they are not filing the affidavit.
You're not obtaining instructions.
Yes, my lord, even my lord.
Huh?
For impugn order, which was annexed in the petition, that was also not furnished to us in the, along with the petition, my lord. That is why we have some confusion, my lord.
Oh.
When
When-
was this order?
Yeah,
When
we are
was
not
it
aware of
furnished
this
to you?
order, my lord.
Huh?
This order, my lord, case number 33, this page has not been furnished to us, my lord.
Oh,
Now I come to know that, my lord, after conducting an inquiry, my lord, deputy commissioner has passed this order, my lord. That is why I need some time to take instruction.
so page 33 was not given to you. Okay.
That was very much available in the writ petition, lordship. But I don't know how that was missing, lordship. Anyway, lordship, the issue is very little, lordship.
Nah,
Because, lordship, my 4th child was born prior to the lordship notification of the amended act, prior to the cut-off date, lordship. That is 19/3/2018 is the cut-off date, lordship.
And my
What is the cutoff date?
cutoff date is 19/3/2018, Lord,
19/3/2018.
18. And my last child was born on 14/3/2018, Lord.
14/3/2018.
Page 26.
And according to them, your child was born on 14/9/2019.
Yes, that is after the.
Then
But
that is a dispute on question of fact.
But Lordship, I have annexed my birth certificate, Lordship, which is issued by the concerned authority, Lordship, appropriate authority, as page 26, Lordship.
Page 26.
Yes, Lordship. That was issued by the Register of Births and Deaths, Lordship. Date of birth 14/3/2018.
So this deputy commissioner, what is this page 27?
Next page 27, Lordship. That is the complaint filed by.
Complaint, my lord, that was made by the General Secretary of AJYCP, Hailakandi, and the President of ABSYU. Wherever there's alleged, they actually made a prayer for removing the petitioner from his post, my lord, of GP member, Panchayat member, and for violating. the
But then
Assam
this is
Panchayat Act.
this date of issue of the birth certificate is more than 4 years after the birth.
Exactly,
Yes,
my lord.
Lordship.
This is
Born in
a
2018 and
disputed
studied-
question of fact.
Lordship, that was Lordship still in existence, Lordship, because I was unable to procure the birth certificate in due time, Lordship. That's why, Lordship, by taking permission from the Deputy Commissioner, Lordship, I procured it, Lordship.
My lord, may kindly note the fact that this birth certificate was issued on 25th of November 2022.
Yes.
Now let's go to the facts of the case, my lord. At page 29. What, page 27. This is the complaint, my lord. The date is 31st of May 2022. Till then, he did not have the birth certificate.
Admittedly,
After that,
Lordship.
let me finish. After that came the a letter that was issued by the Joint Secretary of the Government of Assam, which was sent by the Joint Secretary of the Government of Assam to the Deputy Commissioner Hailakandi, my lord, whereby a report was sought for, my lord. This is dated 16th of September 2022. Even till this date, no birth certificate was there. Thereafter, my lord, 10th of October 2022 is that's at page 30, my lord. This is the letter issued by the CEO to the petitioner, whereby, my lord, the subject bears the violation of section 2(1) of the Assam Panchayat Amendment Act. And it says in the second paragraph, it is reported that you have violated the section 2(1)(e) of Assam Panchayat Amendment Act, and you are asked to explain why action should not be inflicted on you. So till this date also, the certificate is not there. Thereafter, my lord, the next document, which is at page 32, my lord. Here, a hearing was held on the 15th of October 2022, my lord. Even till this date, this birth certificate is not there. So only thereafter, that on the 14th of November 2022, the birth certificate was registered, the birth was registered, and thereafter the birth certificate was issued on 25th of 11/2022. This seems to be, my lord,
My lord, the authorities may
It has to the
verify the authenticity of the birth.
So no, we can ask the DC to decide this issue.
exactly, my lord. In fact, the inquiry
Huh?
was conducted, my lord.
But we can ask the DC.
Lordship, the authenticity of the birth certificate may kindly be Lordship inquired them, Lordship. So,
Authenticity of the birth certificate is not the authenticity, but the authenticity of whether your son was born on as per your submission. The authenticity of the birth certificate will be authentic. Birth certificate will be authentic. Whether the contents inside will be authentic, we don't know.
Yes, Lordship.
Birth certificate as itself will be authentic.
Yes, Lordship. But until and unless that birth certificate is in force, Lordship.
No, that birth certificate after 4 years. That they'll have to see. They'll have to really see.
On what basis?
No, they'll have to see whether the child was really born on the thing and give some grounds, some proof of the same.
Yes.
You have taken a decision. The DC has taken a decision that fourth child was born in 2019. What is the basis for coming to such decision? That has to be there.
Yes, ma'am. Yes, ma'am.
So we'll ask the deputy commissioner to take a decision or what?
Lordship, let in the meantime, that order may kindly be Lordship set aside and directing the deputy commissioner Lordship to have
No.
a fresh inquiry. Because Lordship, until and unless this order is in force, Lordship.
33,
Huh?
my lord, he appears, my lord, inquiry was conducted by the conducted by the assistant commissioner.
And then you find the affidavit.
We file an affidavit, my lord.
Mr. M. Chetia, learned counsel for the
Point number 3.
That's the number.
point number 3. Submit that he will file affidavit within
4 weeks, my lord, because we have last time.
within 4 weeks. List the matter of the 4 weeks.
Lordship, last chance may be given to them, lordship, because lordship, our tenure.
You have not submitted the impugn order to him. That's what he's saying.
Lordship, tenure will expire, lordship, otherwise.
My lord, I'm appearing for respond numbers 1, 2,
5 years.
Mr. C.S. Hazarika,
NK Devnath.
Mr. N.K. Devnath appears for the response number
1, 2, 4, 5, and 6.
1 to 5. Okay.
Obliged.
Lordship, kindly date may fix, lordship.
Give a date.
Obliged.
Senior counsel, Mr. K. M. Chaudhary is on Lakes in court number 9. Lordship, please take after some time.
My lord, in fact, for the respondent, we have filed our application for the vacation of the stay order. At the same time, my lord, our affidavit in opposition has also been filed, to which their rejoinder has also been filed. So, my lord, before Mr. KNC comes, my lord, I can very well, my lord, press my stay vacation application in the process. I will address, my lord, on the merits of the case itself. They will take down the notes. Mr. KN Chaudhary will come, he will give his replies. So. Because, my lord, that's a-
You're for the writ petitioner.
my lord, I am for the respondent NHPC, National Hydroelectric Power Corporation. Because, my lord, the matter pertains to the work of construction of embankment in the lower Subansiri River. Now, my lord, the floods are around the corner. So the work is very important and there is a stay order of the Honorable Court. So that is why, my lord, there is urgency and the matter is coming up repeatedly. But unfortunately, for one reason or the other, it was not.
If we do it, we'll have to decide the entire case. We cannot do it
Yes,
in
my lord,
between.
yes, naturally, I understand that.
Proceedings are
So,
complete.
so, my lord, may I then, I may, my lord, very well start addressing my lord, if my lord permits, they may take down the notes. Because as an applicant also, my lord, I can address my lord. But yes, I will deal with the merits. So if there is no inconvenience, my lord, they can take down the notes.
It may take little after some time, Lordship, after some matters, he will come, he is on links. He has prepared this matter for a final consideration. Just for now, he is on links.
Okay.
But he can reply, my
No,
lord.
no, they want him to hear you also. Let's wait for some time. I have the mix.
I can not review on my lord. Against the interim order, if I had appeal, my lord. This is the order passed by lord. My lord can be.
Whatever, give us more. Hello.
Division was ordered, huh? DB order. Okay, this.
Or TV.
Okay. ये नहीं है हट दिया डीबी ऑर्डर कहाँ है डीबी ऑर्डर कहाँ है डीबी ऑर्डर कहाँ है 11/7 ऑर्डर डीबी ऑर्डर कहाँ है क्या कर रहा है तू कौन सा दिया फोटो कौन सा दिया
Yes, what is this?
My lord, this is a writ appeal, my lord. So
Can we decide the entire matter?
it can be decided. It can also be decided, my lord, no problem, because that is the only point. Main point is that. This case is linked to. I don't know.
So all the cases are having the
Not
same point.
my lord. All the cases are not the same, my lord, some slightly different. But this 21 is exactly similar to that of 26.
21 is similar to
26,
26.
same pair.
26.
Yes. Separately, my lord, they are not, although not linked, but same.
Yes, Mr. Goswami, is that correct? 21 is similar to 26.
No, these are all common questions, below. Almost all the cases. In fact, the first order is of your lordship.
9/11.
What is the case?
Yes. May I please? Well, basically, if your lordships kindly see, your lordship may take up this 7597 of 22. Because I have gone through this, and your lordship may also keep with that 7138 of 22. Your lordship
Is it?
order is in annexure.
He's saying that, Mr. Goswami is saying that we go through 797, 7597 and 7138.
Your lordship started with.
There are also, my lord, some division, my lord, matter is there. Just 132.
No, he's saying that all the cases are similar. Are they similar?
Exactly
Huh?
not similar, but slightly different, my lord, because here, in those cases, the withdrawal of a notification is there, which is challenge. But there is not that same. So your losses may take up, my lord, 1170, this first item number.
1171. Are you ready with 1171?
Look, all cases are similar. If your lordship just takes up your lordship's first order, I think that sums up the issue and therefore there will be no problem. Kindly take up below 7597 because it is annexed to that. That's why I was taking this. The first order is of 9/11/22 and next is 14/11/22. That your lordship will get at page
911.
9/11, page 26.
Where is 7597?
7597.
Page?
Page is below 26, 9/11/22. The first order, my lord, in this.
Yes.
Mhm. No. 26, my lord, your lordship. This is the order in 7138. That was the first case, my lord. The operative part at page 28.
Yes.
The issue is here, that's why I am placing this, my lord. Art so and so, counsel for the petitioners who submits that in terms of the letter dated 2/11/22 issued by the respondent number 3, license fee is to be deposited by the successful tenderer on quarterly basis for the period of 1 year only. However, while notice inviting e-tender, the successful bidder is to deposit the license fee for 6 months within 5 working days of the issue of the LOA or 5 working days before the date of commercial operation, whichever is later. List the matter on so and so. In the meantime, requirement of depositing license fee for the period of 6 months in terms of the notice inviting tender shall be kept in abeyance. The next order is at page 29 is third, 31 equal or 50, 14/11/22. at page 32 below.
Yes,
An interim order to be passed, and they should take instructions on the letter of 2/11/22. Because I'll just briefly indicate the factual situation, because it's very brief. 11.8% put it. Below, your lordships will recall below that there was a stoppage of rail service in the country for about 19 months during the COVID period. So it was a trying time for all concerned, not only in the railway service business, but everywhere else. Therefore, my lord, the government also directed that they should not dispense with the service of the workers so far as these operatives are concerned. So they had also a very difficult situation, which ultimately came to an end after about 19 months. And then, my lord, the association filed a representation before the authorities, narrating the circumstances under which they are operating and the difficulties which preceded and the prevailing difficulties so far as the operations are concerned. So, on that representation, a decision was taken by the competent authority that so far as license fee is concerned, license fee can be paid on a quarterly basis. That was the decision, which your lordships will find at page 93. Your lordship,
the
yes.
representation was made by whom?
By the association, my lord, it is called Indian Railway Catering. The operators have an association which deals with them, my lord.
The page,
It is called, my lord, Indian Railway Mobile Caterers Association. The representation was 27/9/22. So page 93 is the order on the basis of which this was passed, my lord. 93, if your lordship kindly have a look. So it is addressed to the group general manager of all these zones. They are divided into different zones, without the railway. Relaxation in time period for deposition of license fee for mobile units. This office letter of even dated 27/22. IRMCA representation dated 27/9/22. That is the representation I was referring to. Reference above, IRMCA wide representation dated 27/9/22 has requested to allow to deposit the license fee on quarterly basis for a period of 1 year. The management of onboard catering services in trains. The matter has been examined and it has been decided by the competent authority that all SBD and long-term tender licenses within bracket RSD, that is without the Rajdhani, Satabdi, S stand for Satabdi, D for Duronto, G for Gotiman, and train side vendor. So this
just
is
a minute,
This is,
the matter has been examined
yes,
and it has been decided by the competent authority that all SBD, what is SBD?
standard bidding document,
Standard
bidding document.
bidding document.
And long-term tender licenses
Huh,
within brackets. These are the trains, category of trains.
huh.
One is that
R stands for Rajdhani, S for Shatabdi, D for Duronto, G for Gotiman. TV means below their train vending, train side vending. That mobile one gets below there, they can move about on the platform. And ME means Mail Express and TSB is that train side vendor. Shall be permitted to deposit the license fee on quarterly basis for the period of 1 year only. So, my lord, on a consideration of the grievances, this decision was taken that these categories of trains, the license fee, there was a relaxation in the requirement of payment of license fee. It was reduced from the whole amount to quarterly basis for only 1 year. So the objective situation was taken into account and then it was thought that this will be a beneficial act so far as these train operators are concerned. Therefore, it is not that they are given a concession on the amount of license fee. The amount remains the same. Only the mode of payment is now made on the basis of quarters. 1 quarter, and that's all. And it is So also 1 quarter will be 3 months.
3 months, and also it is only for a period of 1 year. So that is the decision. Now, my lord, when they issued tender notices, the requirement was reduced to at page 114, if your lordships kindly turn. It starts at 113 below. Limited tender document, Mail Express. Annexure B. The clause is at page 114, which is really an issue. License fee payment schedule. The above quoted license fee for 6 months is to be deposited by the successful bidder within 5 working days of issue of LOA or 5 working days before date of commencement of operation, whichever is later. Letter of acceptance is to be submitted within 5 working days of issuance of LOA. License fee for next 6 months extension period, if applicable, is to be deposited 1 month before the completion of the first term of 6 months. Bids with offer of license fee, which is less than the minimum license fee, shall be summarily rejected. This is all right. The first clause is the clause which is under challenge, which departed from what they decided. And they say that in advance, you have to pay the 6 months. First of all, they reduce the period of these trains. Normally, they are 5-year long trains. They have reduced it to 6 months plus 6 months. That means it can be extended up to 6 months. So the tenderer has to deposit, selected tenderer has to deposit the entire money of 6 months in advance. And or if it is extended for the next period also 1 month before the end of the first term. So this is what was challenged, that you are departing from your 211 decision, which was taken considering the objective situation prevailing, which called for a certain beneficial act so far as these operators are concerned, and it was thought that for 1 year at least, the license fee will remain the same, but it will be reduced to quarterly basis.
So that letter,
Yes.
21122,
Yes, sir.
requiring the caterers to deposit on quarterly basis.
Right.
It does not have to be postpaid, it can be prepaid also.
Quarterly.
Quarterly, can it be prepaid
yes,
also?
Yes, quarterly prepaid,
Prepaid.
prepaid. And next quarter, suppose it is given for 6 months.
So all these payments have to be done prepaid.
Prepaid. There is no problem on that. So if that order remains, 3 months will be paid beforehand. And then before it ends, you have to pay the next
Yes,
quarter
yes.
payment.
Okay.
So it is advance payment. Therefore, monetarily, there is no loss. Only how you pay is slightly modified.
Correct.
Instead of 6 months entire payment before,
There'll be some loss of interest.
in a way, your logic may be right. But that is the concession that was.
They're provided.
It was their decision, not anybody else's. They thought that the situation is such that it calls for a beneficial to some extent. That's why it was given, the money amount was not reduced, but the period of payment was slightly changed. And therefore, it doesn't depend on the length of anything, but on the situation in prevalence, it was thought that a quarterly payment will, for a year at least, it will be a beneficial act to tide over the situation which preceded this and which is existing on that day for a year. So that is the whole sum and substance of that decision. So when this was given, then we came to court. And your lordship's order granted a stay in the sense that the requirement to pay the full amount was not given effect to. The earlier order was
Should be
kept
effective.
in operation, which they interpreted that it meant only on one train, Gitanjali. Therefore, the others virtually, whoever has got, they have also paid and they continued as they wanted. So the whole question is, my lord, this concession of payment for a year as given by this decision of 211 and the departure from that in the NIT e-tenders, whether it is arbitrary or not. That's the short issue.
Yes. So what is your case? So what is your submission to that effect?
Yes. My respectful submission is this, my lord. If you have taken a decision which is in our favor, it will be arbitrary on your part and discriminatory if you depart from it while implementing the same.
When the period has not ended.
When the period has now been. It's not indefinite, 1 year period. So the idea is to give a benefit to tide over a difficult situation.
But how do we know that that was the reason for giving the concession?
Because that was our representation.
In your representation, it was
Yes,
stated.
yes, that is the only thing we wanted. And they refer to that in the order of 211.
In 211, they refer to it.
Yes, that is the representation.
No, but do they give reasons for coming to this quarterly payment in the
No, it is
quarterly
their
basis?
decision because we have narrated the circumstances under which we are operating. For 19 months, it was no operation, no income. Now you are opening up and therefore you are settled with a lot of liabilities and therefore you wanted that at least give us some concessions. So far the license fee is concerned, that you mentioned, right? So that is the basic grievance which was.
So any citations or what, anything besides that? Anything to buttress your argument?
No.
Any decisions or something? Nothing.
Decision to outside, but what is the reason for departure? There is a reason for a decision.
So there has to be a reason for the decision and there has to be a reason for the departure from the decision.
What is it? That is the whole question. Whether it is arbitrary or not, it will be decided on that basis. Whether it is a fair departure, whether it's an arbitrary departure, the facts will determine that. So what do they say with regard to this?
Yes.
In my respectful submission, my lord, I have a threefold submissions, my lord.
Yes.
The normal period was reduced of these days. Normally it is in their own policy, it is 5 year plus 3, 5 plus 3. But they have departed, that they have their own right. And it has become 6 plus 6, extendable by 6 months if they want. So what you are doing, what they are saying is that this is a long distance train, which is in contemplation. Therefore, it is a long distance train. There is no doubt about some of these, all these categories which I have mentioned in that order below, namely Rajdhani, Shatabdi, Gotiman, and all that. So if those trains are long distance, it is not disputed. The concession or the benefit was not based on distance. The concession or the benefit was on the basis of an objective situation prevailing, which called for some concession as prayed for by these mobile operators and which they thought was justified. So distance is not the criteria. The trains may have long distances, but the reason is not long distance. The reason is the objective situation prevailing, which calls for the benefit as given by reducing it to quarterly basis.
So where do we get this? Where do we get the proof that the benefit provided in the letter dated 2/11/22 had been made on the basis of the prevailing situation of that time and not on the basis of the journey time of the train?
Because if your lordship see the representation itself.
No. Representation can be anything. The decision
Yes,
may be due to some other reason. The ultimate decision might be what you wanted, but the reasons for the same might be different.
true,
So
But-
how do we know that the reasons?
but below
Is
they
the-
are referring to our representation in the order.
Okay, let us see the letter.
Ah.
Let us see the order.
From our representation.
Page 93.
Page 93. Double one. This document is below IRMCA representation dated 27/9/20.
Yes. So it's a very short order. So prima facie, it appears.
And they refer to it that reference, this representation has requested to allow deposit of license fee on quarterly basis for a period of 1 year.
The management of. Where is this IRMCA representation? Yes, I'll just. Because I have to trouble your lordship.
203.
203. 203. 203 of which repetition?
The opposition, my lord, page.
Oh, your affidavit? No. I don't have
Annexure
it.
two, my lord.
No, this is 7597.
759.
It's not that is 209. I don't have 203. I also don't have it. You know what I will do?
Well, the
I'll
opposition
get
will be there.
for you.
Huh? Appeal opposition.
Not in 203. I don't know.
My lord, in the other case, your lordship fine.
You know, your lordship can just have a look at that 1171, writ petition 1171. 1171. Yes. There at page 26 and actually is this. Page 26. Yeah. I'm sorry, my lord, this was not annexed to the earlier one. It's the same thing is there. My lord has got it, my lord, annex 38, page 26. I've got it, page 26. May I take it?
It's okay. It's it.
So the heading of the letter also your lordship must have noted that our prayer was for a quarterly payment. Yes. Yes, so, okay, I've read it, then. So that is the basic thing, and the next page they spell out the difficulties they are facing, less footfalls and all that. It is all mentioned. So it was really pointedly on the question of the quarterly payment. Hopefully that is what is written in the official records. Hopefully the reasons are provided in the same manner as provided in the representation. This is, I know. We know that is the representation made. Yeah. But hopefully in the official records, it is also written in the to the same effect. Oh, yes, they are referring to this letter. 27.9 is in the impugn, in the letter itself at page 93. Your lordship sees that. There is no dispute about that. Reference, number 2, IRMCA representation dated 27/9/22 at page 93. Yes. So there is no dispute on that. Then, so if on a consideration of this, my lord, it was decided that you pay the amount in quarterly basis, then at the same time, you are issuing tender notices departing from while giving, opening up the trains on a 6+6 basis. Therefore, my lord, the departure is very clear. The reason is not spelled out. The reason which is sought to be made is that these are long distance trains. Because Rajdhani is a long distance, Shatabdi is a long distance, all this. So they say that 211 is applicable to only these trains. Okay. 211 is applicable only to these trains. Therefore, my lord, the reason is that these concession is also based. And with regard to the trains mentioned therein, which your lordship has seen, the R and whatever. The order to mention, and that is emphasized by my learned friends also. 93. The matter has been examined and it has been decided by the competent authority that all SBD and long-term tender licensees are SDZPV, ME and TSV. I have given you a lot. So Rajdhani and then second is Shatabdi, D stands for? D for Duronto, Z for Gotiman, T for train side vendor, ME for Mail Express, and TSP for again train side vending.
Train?
Train side vending. They have, they can have those in the platform,
I thought you said G is for Gitanjali or something like that.
That is part of that below the, no, G for Gotiman. Gitanjali is a mail express.
Then T is for
Bigger fund.
T for Timbuktu.
T for below TV. TV is the train side vending.
No, not TSV. RSGTV.
Yes,
What is this G for? G is for Gotiman. T is for what?
T for train vending, Train vending means within the train, I think.
Means what?
There are people who can just, they are permitted to take goods and sell, to the passengers.
And V stands for?
Vending.
No.
This is my understanding. They will know better, I think.
No. Because the TSV is there again separately.
TSB is train side vending without pantry card. They don't have a pantry card. So it is finished products, they say.
Anyway, that will ask.
No, they can tell it. So this is.
So basically, your case is that the respondents are saying that the concession provided for deposit of the fees pertains to only these trains that have been reflected in the order, impugned order.
Correct.
That's all.
That's it.
And then your case is that it actually applies to all trains.
Should.
Should apply to all trains.
Yes. And assuming, my lord, that what they say is correct, then also, if your lordship sees yes, turn to page 94 for a moment, my lord. These are Mail Express trains, page 94. About 84 trains were notified, If the petitioners, now my lord, the submission is to beat that claim, suppose it is the correct situation, what they are saying. If the petitioners have obtained any of these trains, then obviously they should get the benefit.
If they are operating on any of these trains, then they should.
It is all India basis below nowadays. Below the e-tender or pan India. So anybody can have a train anywhere he likes. And moreover, the big trains are reserved for those empanel operators. There is the procedure of empaneling contractors. So if these trains No, what you mean to say is since the petitioners are operating on all trains all over India, the concession provided in the letter has to be pan-India.
Pan-India.
And
It is
so
pan-India.
that is your case.
It is pan-India. There is no problem about it.
So when you asked for the concession, you had not asked for the concession for specific trains only.
No.
You had asked for all
Generally.
trains
Generally,
in general.
for all settlements, quarterly basis payment. That's all we pray for. They have introduced in their letter of 211 that you will get this quarterly basis mainly for these trains.
So you are
Yeah.
admitting, am I right to assume that you are admitting the fact that the concession has been provided by the respondents only with respect to specific trains?
Milord, I have a twofold argument. If you have taken a decision on the basis of a representation of an association representing all their members, then it is essential that you give this benefit to whoever you have selected to operate your trains.
It does not have to be. It can deny some, it can say, no, I'm limiting your concession to this select trains only.
My submission only.
No, I'm, because you're saying something which is,
I am saying I have a twofold submission.
okay.
So my first submission is, my lord, on the parity of Article 14, whether it is long distance, whether it is short distance, whether whatever the nature, the concession is given for an objective situation, which every operator is facing. Therefore, if you decide to give a concession, should it not be applicable to each of them? Article 14 will require that you are equally treating everyone. You are an instrumentality of the state. That will be my first submission. If you limit it to only a few, in a situation which is common to all, then you are really picking out some, leaving others. This is arbitrary and discrimination under Article 14. That is my first submission. Alternative submission is, assume for a moment what has fallen from my lord, that they have a right to choose. Very well, they have a right to choose. You have chosen and given the names. Suppose of these trains, we also get some. We means the petitioners before your lordship. Why will you deprive them of that? There is no rational reason to deprive. It will be discriminatory if you deprive. It will be arbitrary if you deprive. It will be absolutely unreasonable and unfair. All this will affect Article 14. You have to be fair. They are all facing the same situation.
Next point.
So this is the alternative submission. And the petitioners have got, I'll give you a list. Out of these trains, these are the trains for which they have advertised, 84 of them. And they were selected for some. So petitioners were selected for trains notified for bidding and operation. They have to be given. Where is the rational reason to deprive them of? you can't then bring in a argument that, no, these are long distance trains. Their tenure is 5 years and 8 months. But you have yourself brought them to 6 and 6 months. This is your choice. You have not issued any tender for this 5-year mode. You have done it for 6 months, extendable by another 6 months. These are long distance things, very good. So you can't ask us that you pay it at one go. Why should that concession of quarterly payment not apply to them? That will be absolutely arbitrary. There is no reason to distinguish on the basis of distance. The distances remain same. Think of that situation, suppose you issue a tender in the normal period given, 5 years, 3 years, extendable.
Okay. Yes. Yes.
Here, the period is not the question. The situation is the question, which is prompting this concession. And that situation is common to all. Everybody is facing that.
Just 1 minute.
Yes,
Okay,
sir.
I'll just come back.
Again,
Yes.
yes. Ma'am. We have prepared a small chart. We are, yes, the trains where we succeeded. The one is the Jayanta Kumar Ghosh Outdoor Catering Private Limited, the other is Krishna Enterprises. Traffic need to work out in month. Only thing we have not given the serial number of the trains at page.
No, so what is this chart for?
This
Just to show?
chart indicates, when these tenders were floated, they applied. These 2 persons, for example, and they have succeeded in getting the settlement.
On
Yeah.
quarterly basis.
No, they were selected because they are the highest bidder. So, Jayanta Kumar Ghosh, for example, he has got it in 8.
Yes.
He has got these trains
How you got this trade?
out of these 94, your lordship finds all that.
Yes.
So these were all long distance trains. So they have also got it. So they should normally get this quarterly basis. Even if we accept what the letter says, 211. Namely Satabdi, Duranto, whatever it is. So these trains are part of that. Therefore, if you are getting this, you should not ask for 6 months straight away. You should have asked for quarterly. Your lordship's order gave us quarterly, yet they had to, Gitanjali, of course, they have not given us the letter of authority, therefore they are accepting and extending our earlier train, we are running it. But those new trains, they have realized money by saying that you will otherwise lose your rights and all that. So they had to pay. There is no way out. But
So they are paying 6 months.
6 months in advance because the NIT one. Therefore, next 6 months, suppose they extend, the same thing will happen. Therefore, assuming what they are saying is correct, that this is confined to these trains, these petitioners, having participated and succeeded in getting these trains, they're entitled to get that benefit of quarterly payment. Suppose tomorrow, this 6 months already gone, suppose tomorrow they extend. They keep on extending. Monthly, 6 monthly, 3 monthly, whatever they suit. Why should they not get the benefit? There has to be a rational reason to deprive them.
But they might have given up their claim for that.
We are before your lordships.
This Jayanta Kumar
And
is
in
before
spite
us.
of having an order from your lordship, we have paid. Kindly see the situation of these people. The show cause notice was given. That would have repercussions for their other operations, which are not in issue. They may cancel for future. They have those powers. Therefore, we have, under coercion, we have to pay our so-called notice. But that doesn't change the position. Because suppose it is extended, therefore it will have a relevance for that purpose. Because 1 year period is the only period. If you don't give even within that 1 year, then what is the point in giving this concession? The other, the Krishna Enterprises, they have a petition. They have also got 4 or 5 trains. Same situation. They're part of this 94. I will just give the serial number of that train, that will be convenient. We'll identify the trains.
Anything else?
Basically, these are the twofold submissions. One, that if you have given, considering the entire situation, a concession, that should be applicable to all. You can't subdivide groups and give the bigger players and not the small player. Assuming that is not sustained, those who have got through the tendering process, the trains that you offer, why will you not get the benefit for that? They are long distance trains, even for 6 months by their own choice. This should apply to them.
That's all.
That's the basic submission. Because the tenure has been reduced by them to 6+6. It is their choice. The decision is.
Has been lengthened, you mean?
Beg your pardon?
Has been lengthened, not
No,
shortened.
reduced. Normally their policy, long distance trains. which
For
are
5 years.
5 years plus 3 years. They are reducing it to 6+6. 6 months, extendable by 6 months. And for 1 year, they are saying independently that there will be a concession. The question is whether that concession of quarterly payment, it is not loss of money like that.
So you see, the shortening of the period, that is not an issue here.
No, we are not.
Yeah, that's not an issue here.
No,
The only issue is with regard to the mode of payment.
yeah,
That's all.
a mode of payment as per their own, I am saying. You don't give to other trains, I can understand, but to those trains which you have notified and which we submitted tenders and got as hired bidders, why should we be deprived of that? What is the rational reason? There must be a rational reason to deprive. And they keep on doing this Gitanjali, for example. One of the petitioners got much earlier. But he is always under extension because they don't issue the tender notice for the regular process. Your lordship will find it difficult to identify the trains. May I just have them back? We'll identify the trains at page 94. Page 94 trains will identify the number there, then your lordship will be, it will be easier for your lordship to identify. We have not done that.
Anything else?
I think basic is, that's the issue, my lord. And it is not based on any distance or any tenure. This is a situational consideration to give this benefit. And therefore, anything which goes without a reason is contrary to law and Article 14, and that's the argument. We'll give this chart, my lord, after identifying with the numbers at page 20.
Yes, Mr. I think Mr. Goswami has finished.
Yes, my lord. The issue is that there are other petitions. The first petition was 7138, and then this came, and then
Are the issues similar in all the petitions?
I think that is all similar. This is the only issue, whether you are entitled to pay on a quarterly basis.
Yes.
Generally, and secondly, after having obtained the orders.
My lord, these three petitions, my lord, they are relying on this
211.
211.
Three petitions, which three petitions?
That 15, 16, and 17.
It starts from 21.
15, no, I'm sorry. My lord, yeah, 21, 22, and 23.
21,
22, 23, 22, 23, and 24.
Three petitions.
22, 23, 24.
Three petitions.
Three. And
1171 is extra. No? That is a slightly different.
my lord. And the 21 is, my lord, that 211 notification has been modified later on.
Has been modified.
Modified, and it was actually, my lord, said that 1 year from the date of starting of the cook food.
Starting from?
Cook food when they had, just I am giving my lord the background. My lord, what happened? The COVID was in February 2020, my lord. Prior to that, my lord,
Actually, lockdown started in March,
March.
end of March.
Now, my lord,
20th March.
IRCTC issued policy, my lord, from time to time. 2010 policy has been issued, then 2017 policy has been issued. For the purpose of, my lord, this. Now, earlier, my lord, they issue, my lord, the leases for 5 years.
What for 5 years?
5 years term, my lord, they give
To the caterers.
caterers. That is why, my lord, it is reference that SBD and long term. In the 211, my lord, you lost your find SBD and long term. It says SBD and long term trade licenses. Long term means, my lord, what happened? In 17, my lord, many persons were granted licenses, 17 and 18 for 5 years. But since, my lord, March, my lord, the cook food was stopped, March 20. It started again, my lord, last part of November 2022, when Corona has come. So at that time, my lord,
I don't want to interfere my land, but which petition are you addressing? 1171?
7579,
No.
7597, you have this, 7597.
That question is not here. That is in 1171.
No, I'm just giving the background.
I have placed 7597, that question is not here. That is in 1171, which
No.
went to division bench and
My lord. Now, after starting of the cook food, my lord, during this more than 1.5 year period, my lord, they were not operating. They suffered a loss in long-term, my lord, licenses. So they like repression that we may be allowed 1 year left, somebody 1 year left, somebody 1.5 year left, my lord, the tenure of the leases. So, my lord, the railway board, after considering them, my lord, allowed them that 1 year you only left, you deposit it. What are they?
Okay, due to not completing the tenure.
Yes, my lord. Your losses may see that is very relevant, my lord. That is very relevant because during this period, my lord, no fresh policy has been issued. 2/11/22 is the date of notification, my lord. Page 93. It said, my lord, the matter has been examined and been decided by the competent authority that all SBD, standard bid document, and long-term tender licenses, long-term, 5 years, my lord. That is what, my lord, I argued in the other case, my lord, that this is applicable only to standard bid document and long-term tender licenses. Who has left 1 year, my lord, they can pay quarterly. And this has been preponed later on, my lord, that I shall come later on. Now, this is
Now,
on two-
where do we get, where do we get proof of your submission?
Yes.
In some documents, some official records are there to show that.
Look, this itself says, my lord, your losses may see page 93. Page 93, my lord.
10 petition.
Yes.
Page 93, the second para, my lord, first para. Reference to IMC repression number so and so has requested to allow the deposit license fee on quarterly basis for a period of 1 year for management of the onboard catering services in the trains. Well, on to this, your loss will find this is repression is 27/9/22. At that time, my lord, these tenders were not there. The matter has been examined and has been decided by the competent authority that all SBD, standard bid document, and long-term tender licenses shall be permitted to deposit license fee on quarterly basis for the period of 1 year only. Now, this is of 2/11/22, my lord, your loss will see. In the meantime, they have not issued tender for long term because no best policy has been decision taken. So after issuance of this, they have issued the tender, my lord, for short term, 6 months only. It may be extended, my lord, if policy is not taken, that is, say, your loss will see fine here, my lord, that this tender document has been issued here. My lord, at page 107.
10.
Yeah.
This is the first tender, my lord. For 6 months, virtually. You'll also see at page tenure is 6 months. This is not long term, not SBD. This is not neither of the two, my lord. Not neither SBD, nor a long term. This is a first tender issued after the issuance of that, because this is
What do you mean by standard bidding? SBD is standard
documents,
bidding document,
document, my lord.
but that is for how long?
That is also long term.
That's also long.
That's all.
Then why do you say, then why make a difference between SBD and long-term
There
tender
there
license?
may be some difference, my lord,
Huh?
regarding some probably trains, my lord, they are giving this standard bid document, and otherwise they are not. There may be some, but these are not.
No, but then there has to be a difference. When you say SBD and something, what is the difference between that?
That I shall take instruction, my lord. Now, this 2/11, my lord, letter has been issued. This tender has been issued subsequent to this, on 3rd. So that has nothing to do with this tender. Your losses, my lord, I take, my lord. This tender has been issued subsequent to that. Neither that.
You see, one thing we can do, you see, I want to know the reason.
Yes.
for the decision made on 2/11/22. Now, I think that the official records will show the reason for giving the said decision.
Yes.
Once we see the reason given therein,
Yes.
then we can see the reason or the reason for giving this 6 months NIT.
The 6 months NIT is because the
It is,
that policy has been taken.
Okay, anyway, let us see the reason for
No,
giving that
No,
2/11/22.
That 211 document has been issued, my lord, for the existing licensees.
No, I understand.
Yes, correct.
That is what you have said.
Yes.
And probably you are correct also.
Yes.
But for this court to come to a final decision,
Yes.
I mean, that is the crux.
Yes.
Once we see the decision for giving that 2/11/22, then because the petitioner's case is that because of COVID and because of the hardship that they had to endure, now concession was given to all the caterers in terms of their representation for depositing the fees on a quarterly basis
Actually, it's for 1 year, my lord.
for 1 year.
1 year.
And now the letter, the set 2/11/22 specifically refers to that representation made by the petitioner. And the petitioner's representation only talks about the hardship and the loss. Now, what you're saying is on a different footing. You are saying that the concession given is due to the fact that those persons who are having long-term licenses could not complete their term due to COVID. And it was in that basis that this quarterly basis payment had been given as a concession for 1 year.
That is
Now-
not their representation.
Nah,
That is their
that-
representation.
that is not their
Yes,
representation.
my lord, they are also.
Their representation is because of COVID,
Yes.
the problem started and that it applies to everyone. Your case is that it does not apply to everyone. It only applies to those whose term had not been completed.
Yes, whose term has not been completed.
So let us see in the official records, it will be clarified as to whether 2/11 had been made on the basis of persons who could not complete their term, or was it to be given to everyone in general?
My lord, up to 211. Up to 211 only. Not beyond 211.
No, so no.
No.
So
no,
yes, naturally, up to 2/11.
up to
No, but I want to see that order, you see the note made in the official records showing the reasons for coming to a decision on 2/11/22.
My lord, I shall.
That's all, I think.
My lord, but now,
And-
my lord, my submission is this tender has been issued for 6 months only.
Correct,
And this is issued subsequent to the letter dated 2/11.
2/11.
211. And there is a specific clause, my lord, that license fee for 6 months is to be paid in advance.
No, you see, that is,
My lord,
yes, okay. Pay them.
my lord. So after looking into the terms and conditions of the license, tender, they participate in the bid.
Huh.
They participate in the bid and they got the orders. After getting those, my lord, they have challenged this term. Can they do that? First thing, I'm putting question myself, my lord. Merit Development Authority says, after participation in the bid, my lord, bidding process, they cannot
In the selection process.
selection process, they cannot challenge the terms and conditions of the tender, first thing.
No, you cannot challenge the selection process. That's,
But-
but that is on a different footing. But there's one thing. You see, out here, they are saying that despite the letter of 2/11/22, they have been made to abide by the terms, conditions set out in this NIT due to the unequal bargaining power
My lord,
and due to coercion. That's what they're basically saying.
no, my
That's
lord, they should not have participated in the tender process. My lord, how much
but they
submission-
want to earn money.
No, my lord, you also will see.
And
I have taken several grounds, my lord. Jurisdiction point is also there.
you see, so I'm not deciding right now.
My lord,
Yes, I think, you see, I think everything will become clear
yes.
on the basis of the notings in the official records. Showing the basis for coming to for issuing the letter dated 2/11/22.
Yeah.
Once we have that basis, then I think there's nothing much to decide
Well,
after that.
Now, my lord, so far this is concerned, I am submitting that my humble submission, I shall place to the judgments also, my lord, that once a person has submitted a bid, my lord. they cannot
Once a
challenge the
person has taken part in the
conditions of tender,
selection
my lord.
process and he's not
Yes.
selected,
And
he cannot
now
turn around and challenge
they can
the
say, my lord,
selection or the method.
there should be equality, my lord, that is only thing, that I shall place the judgment. Secondly, my lord, the tender, my lord, the tenderers are from, my lord, if you'll also see at page 173,
173.
173. They have got the 6 months, my lord. It is from Kolkata, West Bengal. He is from Kolkata, West Bengal. Tender was issued from Delhi, my lord. And if you'll also see the tender conditions, at page 131, you'll also see page 131.
131.
131. The agreement shall be subject to exclusive jurisdiction.
Delhi.
of the Clause 17.
Delhi
Well,
shall be exclusive jurisdiction of Delhi.
Delhi. Similarly, other pages
No,
are there. my lord.
anyway, 131. Yes, Delhi.
Delhi, other pages are also there, my lord. You have to see page 135.
No, probably they're of the view that they'll get a good order from Guwahati High Court.
I don't, anyway, my lord, I am submitting because why I am submitting this, that tender was issued from Delhi. The petitioners are, some are from Bombay, some are from, my lord, UP, some are from Kolkata, some are from Delhi.
So cause of action doesn't arise here.
My lord, my submission is this.
What about the any portion of the cause of action would arise here?
Well, it does not rise to tender participation.
Ah.
Tender is from Delhi. Tender is from Delhi and they are participating, my lord, at Delhi. Delhi.
Okay,
My
but
lord.
they are going to say that Rajdhani runs in Assam
No,
also.
That is under the subsequent, that is subsequent part. They are challenging the condition of the tender, my lord, now. They are-
Anyway, can you bring that official, because I think there's no point going on and on into this aspect. If you can bring the records, only to show the basis for arriving at the 2/11/22 letter, that's all. Once we go that there, all the other things will fall into place. Because if you want this court to decide with regard to pecuniary, I mean the jurisdiction aspect only. Supposing this court finds that the petitioners have a better case in that aspect, then again we have to go again through the whole rigmarole. So we decide everything at one go. You just give that document, the basis for arriving at a decision. If that in the note sheet, in the file, it will be there. The basis for arriving at the decision made in the letter dated to 11/22. That's all.
My lord, this, that is the 3 matters, my lord. So far, the item number 21 is concerned, my lord. That is the, my lord, that you also seen, my lord, that my lord Porter also is there.
Ah.
Because here, my lord, that letter has been, my lord, modified,
Has been modified.
211 letter,
Okay.
by the letter dated 3/2/23, my lord.
3/2/23. Okay.
If you notice-
To what effect?
My lord, to the effect that 1 year from the date of resumption of cook food.
From
My
the
lord, tenure was earlier, my lord, 211
Yes.
letter was that 1 year from that day. Now they have changed it. They say that 1 year from the date of resumption of the cook food, post-COVID.
so that'll be from when?
My lord, so it will be, my lord, the last part of the November that has already come. Cook food started in the last part of November.
Let us see this 3/2/23.
My lord, page 20 in the 1171, 23. View above referred letters, such as John have sought verification with regard to the direction for submission of the quarterly license fee for the licenses of SBD and long-term tenders as per corporate office letter dated so and so. The matter has been examined and clarified that this is entire office memo. inter-office memo, that the above relaxation for submission of license fee on quarterly basis was permitted only on 1 year from the date of presumption of the cookhood. So they are neither SBD nor long-term tender, tenders. So they have no locus need to challenge this, my lord. They have no locus to challenge it. And this is inter-office memo, my lord, because they sought for clarification and the clarification has been given. First thing, they must be SBD
I
or
think the
long-term
records
tender,
will have to be brought. Let us see the records.
my lord.
We'll have to see, you see, we'll have to see again, it boils down to that same thing.
My lord.
That 21122, the basis for that.
Let it come day after tomorrow, my lord. I will produce that.
Day after tomorrow, we have already got your matter. That stones. The gravel.
My lord.
Next week. After that. You bring, because that is the only issue.
Then only 11th, my lord.
Right, on the prayer of the parties, leaves the matter on 11.
I have got a matter fixed for the 11, don't have it on the
All. 26 also, 26 also, you're right? On the prayer of the parties, is the matter on 11.
11th.
11th May, Thursday.
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 11th is more than- No, no.
11th.
More.
Or should we make a short note? Heard Mr. P.K. Goswami,
16th.
learned counsel for the petitioners. And Mr. G. N. Sayawala, learned senior counsel for.
IRCTC. That's one number 3 and 4. In
uh,
some cases, 3, 4 and 3, 5.
IS,
IRCTC.
IRCTC, full stop. The petitioner's case is that in pursuant to the representation dated 27/9/22 submitted by the Indian Railway Catering. No, Indian Railway, no. What is that? What is their that IRMCA? What is that?
Indian Railway Mobile.
Mobile Catering Association.
No, Indian Railway Catering and Tourism Corporation Limited.
No. IRM, it is IRMCA.
Indian Railway Mobile Caterers Association.
Caterers Association,
Yes. That.
bracket IRMCA. The
IRMC.
the Indian Railways. Is it Indian Railways?
No. It is IRCTC, my lord.
The IRCTC
CTC.
Limited
Yes.
The wing of the railway.
issued a letter dated 2/11/22 allowing the deposit of license fee on quarterly basis for a period of 1 year, for management of on-board catering services in trains. Full stop. The petitioner's counsel submits that the concession/benefits given in the IRCTC letter dated 2/11/22 was due to the fact that the caterers had suffered during the COVID pandemic, during the pandemic. And as such, the same was to be implemented for 1 year. Full stop. However, the respondents have now issued NITs.
This one just.
Wherein the license fee for 6 months is to be deposited by the successful bidder within 5 working days of issue of the LOA or 5 working days before date of commencement of operation, comma, whichever is later, page 114. License fees payment schedule. And this is in writ petition number 7597, page 114. Full stop. The petitioner's case is that though the respondents are now trying to make out a case that the concession slash benefits given by letter dated 2/11/22 was only relatable to
SDB.
standard bidding document bracket SBD and long-term tender licenses pertaining to RSDG TV, comma, M/E and TSV, comma. The said benefit had been actually done for all caterers in view of the situation that had prevailed during the pandemic, wherein trains were out of operation for approximately 19 months. The petitioner's counsel submits that the concession provided in the letter dated 2/11/22 has to be on a pandemic, pan-India basis. And there cannot be any discrimination in giving the benefit slash concession to some of the members of the IRMC. He thus submits that the benefit provided in the letter dated 2/11/22 has to be made applicable for all trains for a period of 1 year. Next para. On the other hand, the learned counsel for the IRCTC submits that in view of the pandemic, comma, persons having long-term licenses, long-time tender licenses, and who had been selected as caterers for 5 years on the basis of SBD could not complete their term of 5 years. It was only to enable those persons to avail of the concessions / benefits provided in the letter dated 2/11/22. Due to the losses suffered by them during the pandemic. Next paragraph. On considering the submissions made by the parties, comma, this court is of the view that the reasons for giving the concessions in the letter dated 2/11/22, comma, as recorded in the official records would have to be looked into to get a clearer view of the issue at hand. Thereafter, the reasons for the departure no, that I think is different. The reasons for departure might be different. Cut that segment. Accordingly, Mr. Jain Sawala submits that he will produce the records within a week. List the matter on 11. When do you want?
Can I some difficulty, my lord?
16.
My lord. Well, this solution will appears on for 1 to 5, 1, 3 and 6.
Mr. R.K.D. Chaudhary, the DSGI, Deputy SGI, appears for respondents number
1, 2, and 6.
1, 2, and 6.
1, 2 and 5. In this, yes, 5.
1, 2, and 5.
1, 2 and 5.
Put it for union,
Yes, for appears for the Union of India.
different in different.
List the matter on
16th, my lord.
16.
16th.
Interim order.
Interim order continued to the next week.
25.
But I think the records will show the reasons for giving that 2/11. Then it becomes clear. Anything?
No, my lord, only thing, my lord, that matter, your lordship may, item 26 also, my lord.
As I put it, item 26 also, item 26. Yeah, the parties are the councils are the same.
Same, my lord, because he is appearing.
No,
for-
are you there, Mr. Goswami, in item 26? Okay, item 26, separate order, but same order.
Union of India, my lord.
Huh?
It will be the same worship, I will be representing the union.
Yes, I said same thing, same.
And lordship, the interim order will continue.
Interim order to continue.
My lord, before item 25 is called, my lord, may I, because item 19 and 20,
Ha.
so my lord, because hardly any time is left.
No time.
And so, my lord, our case will take some time. So, my lord, may I appeal to my lord? If not, because day after tomorrow, it seems Mr. Kane Chaudhary is having his engagements.
Okay.
But my lord, he is agreeable for 9th of this month. So, my lord, could it be, my lord, on 9th of this month? That's a hearing day, Tuesday.
9th, I think we have fixed that 130A. Mr. You can have bunch of repetitions with regard to board of directors. the validity of section 130A of the, that might take some time because there are some constitutional amendments also in that.
Very well, because it seems, my lord, we'll take our chance. If we are lucky, fine. If we are not, my lord, we will take another date. That's the only way out. Because here in this case, my lord, construction of embankment is a very major issue.
Correct.
So it's very important.
On the prayer of the parties, list the matter on 9th.
My lord, I am appearing for petitioner in item 20, my lord, the interim order.
Item 20?
Item 20, my lord.
Item 19, I am appearing DP Bora. Item 20.
And item 20,
Huh?
for the ring petitioner, my lord.
No. 19? 1920. No, your names, it's okay. Do I have to write your names?
Interim order may be continued.
Huh?
Interim
Order 1920, right? Interim order to continue
Yes, my lord.
till the next date.
My lord, I may try to persuade Mr. UK Nair to let me argue the case first that very day. I try. Who knows, he may agree.
Who knows?
Deeply.
In item 25, my senior, Mr. Bidipur is appearing. So he has some difficulty for today, Lordship. So inform the article.
Where is your affidavit?
Lordship, we have the records, Your Lordship. They were supposed to submit document to the authorities, Your Lordship. Some documents are running on the IMF structure, they haven't produced it yet, Lordship.
Okay, right. On the prayer made on behalf of Mr. B.D. Kowar, learned senior counsel for the petitioner. This is the matter after?
Lordship, they on 10th, Your Lordship.
Not so close. Everyone, you are so close.
There's an interim order operating on that part.
They are always interim. How many interim orders are in this court? Maybe thousands. Let him run his shop. He's been running it for so long.
Any date after 17, Lordship.
Running it for how many years? More than 20 years.
It's a new shop they shifted.
New shop. He
Yes,
shifted.
So it has been shifted from the earlier location.
Okay.
It was initially.
Okay. On 24.
All right. Interim order may be. Continued.
Interim order to continue till the next day.
Right.
Yes, madam. What is the case about?
Lordship, I'm a registered contractor under PWD department. I participate in tender process pursuant to NIT dated 21st of 12/2022 for the work of construction of Brahmputra dike from Adialangi, Bahumara under RIDF 27th of November for the year 2021 to 22 at Majuli LSC.
Yes. What?
So Mr. B. Gogo appears for this matter. Lordship.
Do we know? Where is he?
He's in Lakes at pool number 3.
Lordship, we have taken step
Hmm.
as per the Lojima instruction.
Notice was issued on 21/3. No. Day 15/11/22. Then. What to do? No, there's no return of ID card or unserved notice. What to do? On respondent number 3. Will you take fresh steps or what?
Lordship, we have taken first step.
You take fresh steps.
Yes, sir.
No, you have not taken fresh steps. There is no order for fresh steps. There is no order for fresh steps, madam. Where is the question of you taking fresh steps? What to do? Yes, what is your case otherwise? Do we wait for Mr. Gogoi or what? What is the instruction?
We have not received any instruction yet.
Right, Miss
A fine.
A Payeng. For the petitioner is present. Mr. B Gogoi is supposedly on his legs in another court. Post up. List the matter again. Give a date after a week. Any date, any date. 11. Next.
My pleasure of it. On the last occasion. On the last occasion, the respondents are to take, furnish the instruction in the matter, Your Lordship.
Yes,
I have not received any instruction, my lord, so more time may be allowed for filing. Affidavit.
okay, right, Miss
A Bora.
A Bora, learned counsel for the NHM
Yes, ma'am.
is granted a further 2 weeks time to obtain instruction and file affidavit if necessary. List the matter after 2 weeks.
Your Lordship, the interim order.
Interim order to continue till the next day.